declared in terms of the Disaster Management Act, and then specifically refers to COVID-19. And the issue in paragraph 2 was the lawfulness of the disaster regulations and whether the relevant minister had acted in a procedurally fair and rational manner when she made those regulations. But really I want to take the court to paragraphs 4, 5, and 7, which is where the court sets out the general principles in this regard and the approach that any court adopts. Paragraph 4, what is the role of the courts in circumstances such as these? In Lord Aitken's famous dissenting judgment in Liversidge versus Anderson, he made the point that in times of national disaster, the Second World War in that case, the laws are not silent, that they speak the same language in war as in peace. That has always been one of the pillars of freedom, that the judges are no respecters of persons and stand between the subject and any attempted encroachments on his liberty by the executive, alert to see that any coercive action is justified in law. And then refers to Lord Villiers, that the court's first and most sacred duty is to administer justice to those who seek it. And then paragraph 5, in other words, even in times of national crisis, as this undoubtedly is, the executive has no free hand to act as it pleases, and all of the measures it adopts in order to meet the exigencies that the nation faces must be rooted in law and comply with the Constitution. The rule of law, founding value of our Constitution, applies in times of crisis as much as it does in more stable times. And then at paragraph 7, the function of the court is to vet the challenge decisions and regulations made in terms of the Disaster Management Act for their regularity and not their wisdom. For their regularity and not their wisdom, I stress. The reason for this was highlighted by Laws J in the Somerset County Council case, where he said this: although judicial review is an area of the law which is increasingly and rightly exposed to a good deal of media publicity, one of its most important characteristics is not, I think, generally very clearly understood. It is that in most cases, the Judicial Review Court is not concerned with the merits of the decision under review. The court does not ask itself the question, is this decision right or wrong? Far less does the judge ask himself whether he would himself have arrived at the decision in question. It goes on to say, especially where the subject matter of the case excites fierce controversy, the clash of wholly irreconcilable but deeply held views and acrimonious but principled debate. This must be understood even in those circumstances, he says. In such a case, it's essential that those who espouse either side of the argument should understand beyond any possibility of doubt that the task of the court and the judgment which it arrives have nothing to do with the question which view is the better one. Otherwise, justice will not be seen to be done. Those who support the losing party might leave the judge at the side of the case, as he has, because he agrees with their opponents, and that's very damaging. The only question for the judge, whether the decision taken by the body under the review was one which it was legally permitted to take in the way that it did. There's a helpful illustration of this principle in actually a recent judgment of His Lordship Mr. Justice Henny, published in 2024. We've just given a very short extract from it. It's the Rotenbach case, but then it went to the SCA, which upheld Mr. Justice Henny on this. And what happened here was that the school governing board of the Hoërskool DF Malan decided to change the name of the school. And if the court would turn to the SCA judgment on this, at paragraph 7, the court explained, not that anyone in this courtroom wouldn't know this, but explained who Dr. Malan was. At the letter I on page 124, he served as South Africa's Prime Minister from 1948 to 1954. He was instrumental in the promulgation of apartheid as a government policy in 1948, a political system based on racial segregation and discrimination. It's a matter of historical record. The policy of apartheid led to human rights abuses, violent oppression, arbitrary land dispossession, and the disenfranchisement of the majority of South Africans. The ignominious consequence of apartheid still haunts South African society and will probably take several generations to eradicate them fully. So the moral imperative in this case seems absolutely clear. One cannot continue honoring such a person through the name of a school. And yet, both the High Court and the SCA examine whether the process for giving effect to that moral imperative was lawful. So, just the one paragraph from Sir Justice Hennie's judgment, paragraph 163. He says, the SGB in its heads of argument conceded that if it were found that the governing body is empowered by the Schools Act to develop the mission statement in terms of Section 20 of the Schools Act, to determine the name and to change the name, such decision would constitute administrative action as defined in Paja. This concession was correctly made, and then goes on to therefore deal with the consequences in law of that. And similarly, the SCA, paragraph 75 and 76, under the heading, the rationality of the decision to change the school's name, said this, paragraph 75, I find the decision to change the school's name to DF Academy was also taken pursuant to a fair and extensive consultative process during which all interested persons were given an opportunity to express a view. And then in 76, the third line, the procedure it adopted to consult interested parties was comprehensive, fair, and rational. The decision to change the school's name was taken with due regard to and rationally connected to the information before it. So this turned particularly on the question of the duty to consult, but also on the question of what information was before it. But the point is this: an organ of state is not absolved from following a proper process because it believes that its decision is morally justified. And even where all right-thinking people would agree that it's morally justified, the process must be followed. A lawful process must be followed. That is our legal system. What is interesting to note is that the stark position adopted in the heads was not the position adopted in the evidence. I asked the court to go to file 4D at page 1887. Mr. Perumalsamy in paragraph 47 testified as follows: it is possible to hold views critical of Israel's conduct and at the same time consider that the deliberations of the Council on 22 June 2024 raise serious governance concerns for UCT. These two ideas are not mutually exclusive. I believe that an important perspective is lost if the debate is regarded as binary. And then what we have from... Yes.
And then in the Rodenbach method, it's a project review.
Yes.
So they shotgun approach. Question is, you're beginning here with the rationality.
Yes.
And the rules are different. Mr. Penfield says that actually what Paja did actually to restrict with regards to all the requirements that has to be complied with. and to expand. And it says, you can go to page 351, dealing with the principle of legality and the difference between the Paja review and a legality or rationality review. And it says, let me just, what they say, it's actually from page 350. And then the argument still is that Section 33 is still applicable in certain cases. And what Paja did, instead of expanding, it limited the purview and the width of how you can review.
Yes.
That's the argument. And that's why they say we always have a fallback on legality. There's always a fallback position.
Yes.
Although it's a different pathway. Some people argue that based on subsidiary principle, one cannot apply Section 33 anymore.
Yes.
Because we have Paja in the place of that.
Yes.
But what Hoekstra Pence would argue there is that it actually stifles review in the ordinary course. So what I'm saying here is that it seems that the rules, when it comes to the application, and there's a lesser sort of threshold when it comes to the rationality or legality review in terms of this. In other words, what they are actually trying to say here, and what the applicant and what the university is trying to say is that look at the bigger picture. Look at the end and not the means. And what Paja did is to concentrate more on the means to get there. Although one shouldn't brush it aside. That's my understanding. And by doing so, we never get you a proper review. Because it's kicked out along the way. Because of all the obstacles Paja places there. And the ultimate decision that has to be reviewed, we don't get to that.
Yes.
Let me just see. But anyway, but I leave it there. That's the point I was trying to make. I flagged it, but I'll get back to it. So the question then is, well, although Rothenbach was written and Rothenbach squarely, it seems, Paja applied there. And that was also one of the issues I grappled with. What are we dealing with here ultimately? We're dealing with a school or with people that wants to cling to the name of a school or one of the architects of apartheid. And then we have these, in terms of Paja, we have all these. The main question was there was a proper consensus and all of that. And to get around that ultimately to the point, we have to go back to section 1, we have to go back to the Constitution. We have to go back to ultimately, and the elephant in the room will always be what's happening in Gaza. And our commitment as a society in terms of the Constitution, we are bound by and in terms of international law to have a look at that. And that's where the diversity is coming from.
Yes, certainly they're coming from that position. Yes.
From that position.
Yes.
And to get to that position, the argument in this particular matter is they had to, in taking that decision, they had to cross a few hurdles which they did not. And that is what Hoekstra and Penfield are trying to say here. Because you're not getting to that ultimate ideal. And we did not, by applying that, undermine certain of the ideals of the Constitution. We're talking about human dignity, we're talking about all of those things. If one has to have regard with the elephant in the room, which is what's happening in Gaza and the Gaza resolutions, which people are complaining against. But I'm just trying to get about what test and the ultimate test when it comes to a rationality review that we have to apply. It cannot be as strict, in my view, as a partner review. If yeah.
Is the foundational statutory requirement here. In other words, one has to determine what the best interests are. Once one has that in our submission means, well, you must know what the impacts are. Otherwise, how do you determine best interest? You can't jump over that and say, well, we can ignore that question because we have an ultimate position here. Because you don't know, you haven't weighed anything up. But also, if I may just get back, just on the Rotenbach, yes, not at all. In the Rotenbach judgment, your Lordship referred to Padja. Your Lordship may recall that in the SCA judgment, the court in paragraph 37 said, or paragraph 38 said, the question whether it was administrative action as defined in Padja was not an issue that was pursued in that court. But one of the reasons why I took the court to the heading before paragraph 74 is that there the court was dealing with rationality. And under the heading of rationality, it referred to the fair and extensive consultative process and the need to have information before it. Because how does one arrive at a rational decision without that? If I might ask the court to have a look at how Mr. Arendse rejoined to what Mr. Perumal Sami had put up, and this is in file 5D. At 3154. 3154. And I think it might address the point, Justice Henny, that you raised. Mr. Arendse says in paragraph 19.6, affidavits also not needed to convey an important perspective that criticism of Israel's conduct and concerns about governance are not mutually exclusive. Nowhere in the answering affidavit do I suggest that the crisis in Gaza is so serious that the council was entitled to act irrationally or abandon good governance. I would have put that sentence somewhat differently. I'm sure this is what Mr. Arendse really intended, that he does not suggest that despite the seriousness of the crisis in Gaza, the council is entitled to act irrationally or abandon good governance, and that must be correct with respect. Otherwise, there's just no limits to what public bodies can do in pursuit of what they regard as a worthwhile cause, and again, one that other people may agree is a worthwhile cause, but one still has to go through the process.
Mr. President,
yes.
Please bear with me. I just need you to address an issue. You can continue with your presentation. We know from the records that on the 27th of July 2024, the council voted not to pass the resolution.
Exactly. To implement.
Not to implement.
Well, no, to implement, yes.
And the 15th, and the reason for that, for the resolution, it was pending an investigation into the financial implications.
Yes.
And now on the 15th of March 2025,
yes,
Council again voted not to rescind
yes.
the resolution. Now, I want you to address the court as to what is the impact of these resolutions, because it seems as if then there might be no wonderful review if council has already decided that we are accepting the resolution. What is the impact on these proceedings of the two resolutions, one, the 7th of July and the 15th of March?
None at all, with respect, my lady. And the reason for that is it's simply the same council just reiterating its position. But to take a little further, you can see UCT is itself not very confident in its contention of mootness, which they do raise in their heads. Paragraph 25, you might ask the court to go there. The submission is made that this review is therefore in large part academic or moot. Now, what does that mean with respect? And that is either moot or it is not. So there's no confidence in the formulation. Mootness was not raised on the papers. On the contrary, if I may ask the court to go to file 4A, answering affidavit at page 1071,
Mhm.
1071 in file 4A.
File
4A.
Right.
Oh, sorry.
Page.
Oh, sorry, this is correct, yes. At 1071,
Paragraph 255.
255. The events that took place after the council took its decision are irrelevant to the merits of Professor Mendelsohn's review. The review of the decision on 22 June 2024 does not entail an ex post facto evaluation of the council's decision with reference to facts and circumstances that arose after the council took its decision, which were unknown to council at the time. Now, granted, it refers to being irrelevant to the merits, but still, one can't say that in an affidavit and then in your heads of argument suddenly raise mootness. It's a factual, it has a factual component, and that should have been raised squarely so we could deal with it. But it's in any event not moot.
Let's say the decision in issue nullity.
Yes,
You are.
exactly. Then that's the end of that.
It's the end of that.
Yes, because you can't, exactly.
And
That's perhaps a good way of looking at it,
decision
yes.
After the financial implications were discussed and after it became known that the GDF have already withdrawn their donation of 200 million and stopped. Said we're not going to build the hospital anymore. After the Bell Foundation said, look, we will continue with the current students, but we will not. Council sits again, a new council.
Yes.
With those facts in mind. And they make and that second decision. Your claim is council did not place all the facts. They withheld certain members of council.
Yes.
The executive withheld the initial decision. The fact that there is a possibility the Donald Gordon Foundation may withdraw funds, may stop, withdraw from the agreement, also that the Bell Foundation.
Yes.
Except that was there, and as a result of that, that decision is nullity.
Yes.
Supposed to be reviewed and set aside. Now you have the decision of the 15th of March. And let's say, well, let's just take a step back. If on the 15th, if that's 2024, February 2024, when the initial decision was taken,
June 2024.
If those facts were before council, and council said, notwithstanding those facts, you're going to lose 200 million rand, they're going to withdraw the substantial, they're going to withdraw from that contract, they're not going to give it any further funding, we're going to, the donors are going to withdraw. That's the, that was before council. Would that decision have been, could it be appealed?
Yes, because they still haven't consulted. There are various legs to this, there are various aspects to this.
Consulted in what respect?
With the university community, as in the Rothenbach case, where your lordship as well as the SCA said that's part of what must be done.
If I understand Mr. Nkatomi's argument, I always think that we must just excuse me. I always don't pronounce it correctly. But if I understand, that's an executive decision, and the requirements for consultation when it comes to executive decisions, which more or less than what we deal with mostly are polycentric, and we deal with the members of parliament, sorry, not members of parliament, the president and the executive makes a decision. Question is then, and I suppose they should have, they could have followed the Rodenbach process. We had all those, but they were compelled in terms of either section 3 or 4 Pajak to go through that process.
With respect again, my lord, the SCA didn't refer to Pajan, this is a rationality.
Let's say that.
Yes.
Let's say it was a rationality, but that was your argument for me.
Yes.
So you're saying there's still, if the decision before council, the initial decision, if council members were made aware, look, if we're going to go through with these two decisions, we're going to lose that funding. Are you saying that also have been not lawfulness?
Yes, but we don't even get there with respect, my lord, because the question is, was the decision in March 2025 one that could stand alone. Now, I'll put it this way. The question when the court will ask itself in regard to mootness is, will setting aside these decisions have any effect? And the answer is yes, they will, because what was being decided there is whether to rescind these decisions. We weren't taking new decisions. So really what happens is that decision on rescinding or not, that simply becomes irrelevant, because this court declares that in the first place, those decisions were not valid. So it's a completely different decision that was being made in March. And this court's order will definitely be effective. Nothing will survive of the resolutions by virtue of anything happening subsequently.
So it would not make it imperfect. In answer to what it would not have made it different.
Yes.
Because some other aspects were lacking.
In any event,
And
yes.
in this case,
Yes.
consultation with the university.
Yes. The other thing is the argument seems to be that by 15 March 2025, the council had received the founding affidavit and supplementary founding affidavit, and therefore had much more knowledge. This is what's said in paragraph see where it's, anyway, I think that's the correct position. I think I'm correctly describing what the position is on behalf of UCT. We'll take that in the first place as a concession that UCT should have had more information before it, at the time, made the decisions initially. But also, it's still nowhere near enough homework having been done. We'd have to challenge that on a completely fresh basis and say, but you still hadn't undertaken an impact assessment. Bearing in mind, to the papers is annexed the 2019 impact assessment. We call it that. Actually, I think it seems to be January 2020, but for convenience, everybody refers to it as a 2019 impact assessment. That's annexed. But UCT's case is that that's irrelevant. We don't agree with them, but their own case is that's irrelevant because everything's different. That means they must undertake a fresh impact assessment. They must know what the impact is on the university. As I said, there's still no consultation. There's also a further point. The considerations are different when you're deciding whether or not to rescind an existing decision as opposed to making a decision afresh. For instance, one may, on good cause, decide, I didn't support that decision initially, but it's now been implemented for a period of 8 or 9 months. A lot has happened. Rescinding it will have all kinds of unknown consequences, and therefore you don't rescind it. Very, very different questions you ask yourself as someone voting at that stage. So on all these, for all these reasons, we would submit that mootness simply doesn't arise. Yes.
In fact, that much is clear from the fact that there was a time. So that means there had been a paradigm shift from some of the voters. And it had to be the chair who cast the deciding vote. So that tells you already that there's been a shift, because the first vote was 11-6.
Yes.
Now we have a situation where now there is a tie.
Yes, exactly. Yes. I think the casting vote was for another round, but the last vote was a 14-13 one. Indeed.
No, the last one was 14-13.
14-13, as the court pleases. One might also have raised, for example, if there were a challenge to the failure to set aside the resolutions, that some people are not coming in with an open mind because they're now wedded to this. There are all kinds of other considerations, but the one doesn't simply substitute for the other, is the basic point. And I say mootness is raised belatedly and is raised, let's call it skittishly, carefully. This is not a case that our submission is moot. So as I said, Mr. Orenser accepts that the council is not entitled to abandon good governance. Good governance encompasses acting in a lawful manner. And what's important about a fair process, not only that it's legally required, it also assists in attaining a more correct outcome. And in that little bundle, we have provided the court with one of the many all-pay judgments, where paragraph 26 and 27, the court makes this point. So with respect, it's a self-evident proposition, firstly, that a fair process or a proper process leads to better decision-making. It's also the reason why the Constitutional Court projects the no difference principle. You can't just say, well, you can't assume that. And that's also referred to in these passages. But what's said here in paragraph 26, this clear distinction between the constitutional invalidity of administrative action and the just and equitable remedy that may follow from it is not part of our pre-constitutional common law review. Procedure and merit were sometimes intertwined. It then says it was not a general rule, and even under the common law, the possible blurring of the distinction raised concerns that two should not be confused. And then says procedural objections are often raised by unmeritorious parties. Judges may then be tempted to refuse relief on the ground that a fair hearing could have made no difference. But it's vital that the procedure and the merits be kept strictly apart. So that's the rejection of no difference. Then goes on, there's a further consideration. Deviations from fair process may themselves all too often be symptoms of corruption or malfeasance in the process. In other words, an unfair process may betoken a deliberately skewed process. Hence, insistence on compliance with process formalities has a threefold purpose. A, it ensures fairness to participants, that's in the bid process, but obviously mean any stakeholders. It enhances B, the likelihood of efficiency and optimality in the outcome. And C, it serves as a guardian against the process skewed by corrupt influences. But that second one, it enhances the likelihood of efficiency and optimality in the outcome through a proper process. The quality and rationality and legitimacy of decision-making is enhanced. So our submission is, as a matter of law, the position that's been adopted by our learned friends in paragraphs 123 and 155 of their heads of argument is just wrong. The question then is, why does UCT seek to argue this? And our submission is it has no real alternative, because we know as a fact that council did not undertake any investigations before adopting the resolutions. It had no salient information before it, and it didn't consult. We know about the paucity of documentation before it from the Rule 53 record, as then subsequently explained. What was before it were the two Senate resolutions. So UCT seeks to rely on an opposition between moral imperatives and financial considerations. Sometimes they reduce that to rands and cents, as though one should underplay the role of money here. As Mr. Perumalsamy pointed out, the moral consideration does not absolve the council from taking account of other relevant considerations. UCT does not suggest, because of course that would be absurd, that adopting the resolutions would have any impact on the war in Gaza. That's not their case, correctly. Its concerns are essentially reputational. But what that means is that these are all concerns internal to UCT. What are the consequences for UCT? So they talk about the reputational benefits to UCT. But once one's in a closed system, as it were, once you are looking at how is this good for UCT, you must also look at how is this potentially bad for UCT. You have to do a cost-benefit analysis. The positive impact of adopting the resolutions must be weighed against, compared with the negative impact of doing so. And UCT here took no account of the negative impact. We are in alignment with our learned friends that the ultimate determinant here is the best interests of the university. Our learned friends say this in paragraph 126 of their heads of argument. They refer there to the best interests, but then they try and qualify it by saying it must be assessed in the light of certain things, but of course it must be assessed in the light of everything that bears on this. It's a determinant of it under the governing statute, and the first document in the little bundle we've given the court is the Higher Education Act, or the relevant sections from it. It's really section 27 that matters. Section 27(1), the Council of a public higher education institution must govern the institution, and we submit that that means must govern in its best interests, the fiduciary position, but in any event, it's made express or expressly stated in section 27(7)(b). A member of council must participate in deliberations of the council in the best interests of the public higher education institution concerned, so the university in this case. And best interests is a fairly simple submission, means that council members must look at negative impacts as well. Possible negative impact are not merely financial. Firstly, it could also be reputational. For example, neither party has been able to identify any other university that has infringed on the academic freedom of individual academics. Curtailed them from having working relationships with broadly Israeli academics, but we'll look at that, what that means exactly later on. When a university curtails academics, indeed, yes. So that's a separate issue. That academic freedom. Yes. Indeed, so prima facie it does, but it infringes. The point I want to make here, just Henny, is that it infringes in a very specific way, which is not, in other words, on those individual academics, and because it appears to be unique, there's a risk of reputational harm to UCT from that. My only point is this wasn't examined. Other universities who also have adopted resolutions as a result of the war in Gaza, they didn't do this. Now, when a university curtails academic freedom, it obviously risks reputational damage, because universities generally think of themselves as protectors of free speech, including, of course, in particular, academic freedom. But also, the concern isn't about the loss of funding per se, because universities are not for profit. It's not about, at the end of the day, show a profit. It's what that money is for. It's the impact of the loss of funding. So there's nothing crude about referring to money here. Money matters, unfortunately, very much to universities. It's their lifeblood. They depend on it. For example, the Dell Foundation, according to the answering affidavit, was funding in 2024 288 students. I'm not going to ask the court to go there, but the court wants a reference. It's paragraph 200 of the answering affidavit, volume 4A at 1052, and will not in future fund further students. And that, with respect, is a tragedy. And the moral issue then becomes complex because a decision by UCT that causes this funding to be terminated has moral implications, because the potential of many young people who might have been able to study may never be realized. And money goes to research, and we know it has a lot of research in the medical field. And TB research, for example, it matters in this country. Still, I think, according to one of the affidavits, the biggest killer in this country. So there are moral implications in taking decisions that reduce funding, for example, TB research. It's a complex moral question, and it had to be examined very carefully. Flows from the loss of funding. Also, a 500 million rand hospital that may have been donated to UCT has now been donated to Stellenbosch University. Again, that's tragic for the University of Cape Town. It's a teaching hospital. Donation of 200 million rand to the Neuroscience Institute has been forfeited. So if Council had taken the trouble of having regard to the 2019 impact assessment, or had obtained a fresh impact assessment, it would have learned much. So I might ask the court to look at file 3B.
How else?
Yes.
Was it funded in the beginning, especially with regard to the definition of, if you go back to the Wooden Foundation,
Yes.
of the IHRA definition.
Yes.
That was something that they wanted to do.
It was in the, with respect, the hell or high water is not clear from the
Maybe
paper.
not, but the argument was it must subscribe to that definition and sentence.
With respect, not quite, Justice Haley, because what happened was it definitely referred to it. But bear in mind, the IRA definition is the most widely used definition.
Wasn't that clause drafted by UCT?
The final version was drafted by UCT.
It was inserted in the agreement by UCT.
Indeed.
With the chairperson was
Twice.
Yes.
was
Once in September and once in November 2023.
Which is significant given what happened in October.
Indeed.
I understand that. The point is that if we receive that definition has stayed and that continued to be part of the agreement,
Yes.
it would seem that finally not have been good. They want another assurances,
Yes.
take thousands of minutes again and see. The biggest drag that was taken was sort of in place with the Jerusalem
Declaration. Yes.
declaration. You can see that the Donald Good Foundation, I didn't want that. Usually agree with how the argument did. The argument was being used and weaponized
Yes.
the IH.
We call it the IRA definition.
It has been weaponized for other purposes. Although on paper it would seem to be non-contentious except for few, but it has been weaponized by governments, even it seems that Dr. Mendelsohn, Professor Mendelsohn, was in agreement with the Jerusalem Declaration is much better and practical one. See, later on, disagreed. I don't know. There's nothing on record as to why he says that is not good enough for that he went through his support to that. Yeah, yeah, and then and I think that was one of our main issues also with regards, and that's why our system presiding here had this discussion here initially and say, why can't, you know, but the point I'm trying to make is that without that definition in that agreement, there would be no funding from the government foundation.
So your Lordship putting it slightly more strongly than Mr. Arendse himself put it. You may recall Mr. Arendse. But Mr. Arendse says that he took the view that they may still be able to save the funding, notwithstanding the rejection of the definition. But what your Lordship raises is, with respect, a really important issue. Your Lordship is raising this now you're making a decision, council is, to reject the IRA definition. That goes directly contrary to a term of a 200 million rand donation, which was signed not long before.
Yeah, by Mr. Arendse himself.
By Mr. Arendse himself. And this is not known by council. And with respect, it is so extraordinary. It is such an extraordinary omission. Failure to place before them even that.
And then in the council meetings, when it gets to that question, there's no debate. In fact, the chair puts forward and says, we must adopt it. He puts forward the proposal that they must adopt the declaration.
Yes.
Are you going to get to this issue about the resolution and specifically these two definitions? Are you going to elaborate on that, or do we need to engage? Yes, in this whole debate, are you going to get to that, or do you want us to engage? Because I have some. Right. Well, firstly, if you look at the resolution as it was phrased, they took the Senate resolution and adopted it. And there's a noting section and a believing section. Now, the noting section and the believing section, both in both those sections, they say that the definition has been weaponized. They don't use those words. They say there's been conflation with critique of Zionism and Israel based on the IHRA definition. Does that per se mean that the definition is wrong and must be rejected, or is it the weaponization and misuse of the definition? Is that so? That's the first question I have. Secondly, if one looks at the Jerusalem Declaration, it too refers to the state of Israel in a number of the examples it sets out. It is too, it seems to me, capable of being weaponized and misused equally. And the third question I have is it appropriate for an academic institution to get entangled in this kind of thing? It seems to me to be akin to a sensitive, almost doctrinal question that was not necessary for the university to get involved in. It is something that Jewish scholars have wrestled with across the board. If you read what's going on here, there are many, many debates about this. And there's a third way of looking at it as well. Was it at all necessary for the university to even go there? Why did it stay with the noting and the believing? Why was it necessary to go and then say we are rejecting, knowing that this is the linchpin around which this donation depends. Was it even necessary to have it there? Some knew that. Five of them that were there knew about it.
Agree with what your Lordship has raised. Your Lordship will note too that we did refer to actually Palestinian organizations and Middle East experts who say that the Jerusalem Declaration is not good because it gets weaponized. And that goes to the point, if one is a bad faith actor, you can weaponize anything.
You can.
Because,
I mean,
because weaponization is dependent on acting dishonestly.
Yes. Would it have been appropriate, for example, for a university to say there is discrimination against students who follow Islam?
Yes.
We think that, I don't know if this is at all correct, I'm just surmising for the purpose of an example. We say that it would be correct for us to follow the Sunni definition as opposed to the Shia definition of what Islamophobia constitutes if such a hypothetical situation is capable of being postulated.
Assuming such an hypothetical situation, the answer with respect is no. It's not for the university to do that. But your Lordship goes further. The very definitions weren't before council.
Sorry?
The very definitions weren't before
they were not
council.
Yeah, it was before Senate.
And they're quite long documents, and require close reading, frankly, and the number of skilled lawyers on council, and this just wasn't properly considered at all.
And then what I find also troubling is that there were discussions being held between the Neuroscience Institute, the donors, and Professor Mendelsohn was involved with that. And this issue of the definition was on the table, but there was a possibility perhaps of resolving this. But no attempt was made to either disclose this to council or to say, let's pause.
Yes.
Let's see if we can't get Professor Mendelsohn, who seems to be on very good terms, well respected according to the donors and the academic community. Can we not see if we can at least get that perhaps dealt with, so that we don't need to have this inserted in the resolution, because that is going to mean that the breach is not cured, because the donors said you're in breach. There's the clause. You drafted the clause. You, UCT, put that clause in.
Yes.
It's your clause. You're in breach of it. Was any of that disclosed?
There's nothing on the papers. And for example, just picking up on your Lordship's point, why did no one go to the Donald Gordon Foundation and say, could you live with an amendment where we reference not the IRA definition, but the Jerusalem Declaration? Don't know what the answer would have been, but why was this not explored? It is a very peculiar way of going about things.
Can we go to the resolution perhaps and just look at it? Because I think, as I read it, it was not necessary for that to be there. The noting and the believing said what needed to be said.
I do think that going through the resolution, maybe our purpose should be to interrogate what exactly was on the day of the meeting, because the proceedings turned into the review of what happened on the 22nd of June. So perhaps it should be in reference to
Yes. The actual resolutions your Lordship will find in the most accessible form in file 5E, actually. It's quite a long way along. As an annexure, 5E is an annexure to the Sarah Joinder affidavit. At 3671 and 3676.
Sorry, 5E, 33,
3671 and 3676.
3671. No, sorry, I'm not talking about what was put forward. I'm talking about what was adopted.
Oh, at the council meeting itself.
Yes.
I apologize. Yeah.
Can we now take the response and it will be 15-minute break?
As the court chief.
Thank you very much. God bless you.
Well, this is one. Downstairs and turn right. Okay. Oh, there. Just 1 second. Good. Well done.
Yes, I have it. Thank you.
So apart from paragraph 6, which is the one that's problematic, and paragraph 16, the rest essentially put the case forward for the university. It had passed a resolution in almost those identical terms in 2023. Not identical, but certainly passed a resolution condemning what was going on, calling for a ceasefire, calling for humanitarian aid, calling for the release of all captives. All of that had been passed as a resolution previously, and there was no, well, certainly doesn't feature as a point of contention in this matter. So was it necessary to go and say what is said in paragraphs 6 and 16? Not.
Rain, where it just has no expertise, no knowledge. As your lordship said, these are academic debates. No homework done on this question of weaponization. The court will recall that we're dealing with hundreds of pages of annexures to the answering affidavit saying, but look at all these articles on weaponization. But Mr. Aronson never says he read those. No one says they read those at the time. Mr. Aronson, as Justice Henny pointed out, in November 2023, signed the agreement. So somewhere between November 2023 and June 2024, he would have had to have read all that, but he never says he did and could change his mind.
But the point is, any of these definitions is capable of being misused and weaponized equally.
Yes.
If you look at paragraph 6, it says that the IRA statement conflates. It doesn't do that. It says in paragraph 6, the IRA statement on anti-Semitism conflates criticism. That's an interpretation. It's not correct to state that the definition does it. Again, is this something that counsel should properly have expressed a view on, should have got involved in? Was it necessary to do so? And especially knowing that this is the definition which you have put into the contract with a donor that's going to give you 200 million rand and says to you, you're now in breach. They told them they were in breach in April. 30th of April is a very clear letter written by Mr. Applebaum. And none of that is put before counsel for debate.
Lord, on that, it's particularly perturbing given that one had questions asked expressly by council members. Dr. Cardo was one, but also others, saying, what are the implications for the university if this is done?
Yes.
Yes. Not even that. What are the potential implications?
That's speaker number 8.
Indeed. Oh, I forgot. Yeah, speaker number 8. I think.
Speaker number 8.
Yes.
and
nobody's.
Speaker 18 also. What are the implications?
Yes, I think 18 might have been Dr. Cardo. And nobody says, none of the people who knew says, but there's this. Now, the chair raises as his defense to this that he didn't think that it was ripe.
He thought it was premature, and he says he thought there was no definitive pronouncement. So therefore, somehow it's not necessary to even raise. But somewhere he says, he recognizes there was a possibility. Is it necessary for it to be definitive for a fiduciary before a fiduciary exercises their duty? Must there be a definitive chance of it? Or what do you say is the duty that a fiduciary has?
That determines it. There was risk.
Look, the chair says in I think this is page 163 or something around there. I think we could get that again. I think it's written in the head. It's and nobody comes to the fore
Yes.
although the plea is of speaker number 8. What are the implications of this? He asked it more than once,
Yes.
and has not been adhered to. You can just see the one very good that you have to go back to there. But then he says, he speaks about funding. He has the risk of losing funding,
Yes.
but not
this.
what he knows with regards to what the Donald Gordon Foundation and the Dell Foundation are doing. He says, he says this where in the papers. Is my, but I think if you look at the record, it's a long speech because he tries to answer speaker number 8 and 18.
Yes. Page 681.
681. Thank you.
Volume 3B.
Volume
3B.
Yeah, he tries to.
In 680.
Yes, he says. And I think he says that it would seem that the financial considerations, that is a different consideration, he says, page 681.
Yes.
Then he says, well, that is a different consideration.
Yes.
Then it could also be regarded as quite a sad day that we are held to sort of hostage or to ransom because we are going to lose funding.
Yes.
Because that was a big issue in Senate. I remember a few years ago. And in fact, you were asked to make those records available about what we potentially could lose if we adopt certain resolutions that are perceived to be anti-Israel. If that is released further, and that is interpreted because the IRA definition is being actual anti-Semitic, which is not. So that is a different consideration. If that is what we are scared about or afraid about, then we will need to be upfront about it. But then we must not, in other instances, talk about the rule of law, talk about social justice, talk about our commitment to international law.
Yes.
So he says, so he raises that question and I think he tries to answer it. But the crucial fact that we are in the process of funders that will be withdrawing funding. That is not revealed. I think
Indeed.
that's
And
the crucial question. So the question of losing funding came up
yes.
in answer to number 8. Although they speaker number 8, although they don't answer speaker number 8 or 18 in detail and say, okay, well, let me be upfront with you. We have been in discussions with the Donald Gordon Foundation and the Dell Foundation, and this is what we can do.
As the court pleases. And the defense of ripeness also with respect falls down on its own terms, because where that's taken from are the terms of reference of EXCO, which is in file 4D at page 2094.
Four D.
4D
2094.
2094. And the court has that paragraph 3. The committee's purpose is to attend to process issues and preliminary decisions or matters that in the judgment of the chair are not yet ripe for plenary council consideration. Now, EXCO had dealt with this in May. So why then is it now not ripe for plenary council consideration? And moreover, if one looks at D, EXCO will refer any matter that is not routine to full council. And this is not routine. It's a 200 million rand potential loss of donation. So ripeness with respect just simply doesn't assist as an explanation. It's also the chair's explanation. The other EXCO members presumably also made some, but why did they not say anything? If one takes a counterfactual, assume an EXCO member who was either entirely neutral on the resolutions or was in favor of or against their being adopted. One can't imagine such a person not responding if the question is asked and saying, yes, there are these financial implications. I know about this Donald Gordon Foundation, 200 million rand. So there's a denial that they caucused and agreed not to tell their fellow council members about this. But if they didn't caucus and agree, that's more concerning. That means each of them individually decided, I'm not going to disclose to my fellow council members this really important information. It's really not how a university council should function.
It's very concerning given the timeline as well, because the letter's written on the 30th of April. Then you know from the correspondence, there is correspondence from Professor Figan as head of the Neuroscience Institute, round about that time,
Yes.
involving the chair, the vice chancellor, and Professor Mendelsohn, and there are clearly discussions on the go. Then there's the EXCO meeting of 23 May, and what is said there, and then you have this meeting a month later, 1 month after the EXCO meeting.
On the Figan letter, if I might just ask the court to go there, it's in 4B. 4B, 1568. Professor Figan writes this email to Mr. Arendse, and in the second last paragraph on that page, he says the major concern is that in rejecting the IRA definition, which is specified in our donation agreement, UCT would be in breach of contract, and the foundation is considering withdrawing on that basis, which would be disastrous for the Neuroscience Institute and for UCT more broadly, as we are also in discussion about what may be an even larger donation to support UCT private academic hospital. And then over the page, he goes on to explain the options being considered are cancellation or continuation, and of course discussions around the private hospital are on hold. And then one has actually a follow-up on this in file 3B at 789. From the Neuroscience Institute, one of the signatories there is again Professor Figan, which 789 in file 3B. The governing board of the Neuroscience Institute express our deep concern about the impact of recent decisions by the council, which have had significant fiduciary consequences for the institute. We note that these decisions were made without any consultation with the leadership of the institute. Now, they've been warned of this by Professor Figan, of this potential consequence, and they didn't consult.
What is the date? Sorry, my copy is not.
20 November 2024.
November.
This is after the fact.
Thank you.
The Institute's success is closely intertwined with the confidence and sustained support of philanthropic donors who share the vision of advancing neuroscience in Africa. And I just stopped there. This is again comes back to this moral consideration. It's complicated and should have been weighed much more carefully. It matters when healthcare, neuroscientific healthcare in Africa is compromised by a decision such as this. Unfortunately, Council decisions have directly jeopardized this donor confidence in the Institute. This threatens the very future of the Institute, which relies on donor funding, amongst other things, to implement transformative programs.
So, am I correct in if my understanding of the papers is that there was no suggestion that this funding was in peril because of the resolutions taken at the end of 2023? And they were quite specific and clear in their expression as to what was going on in Gaza, their condemnation of what was going on in Gaza. So there was no issue as far as the funders went with that. In fact, in the council meeting, it is suggested by the chair on more than one occasion, in an attempt to arrive at some kind of a consensus. He says he's concerned there are differing constituencies, there are divisive issues. Why can we not just note, he says, can we not just note the Senate resolution and reaffirm what we said in 2023? If that had been done, would this funding have been withdrawn? No suggestion.
And once again, speaker number 8.
Very definition that the university signed on.
Which the university put into the contract.
Yes,
it's not as if it was imposed.
Yes.
They suggested at some point it was imposed upon them. Well, that's the impression that some of the debate is, well, we must be careful that we don't kowtow as a university under pressure to the influence of donors, donor privilege, donor power, donors dictating the moral imperatives, the moral policy, and the positions adopted by the university. Quite correct. But what's not disclosed to council is that, in fact, that definition was there because the UCT put it into the agreement.
Was that, because that's what Mr. Applebaum says. So
Yeah.
I don't know what the prior iterations were, in fairness.
No.
But the point is, yes, the final draft was UCT's. They were happy for it to be there.
Yeah.
As has been pointed out, was signed twice, once after October 2023. There was no issue with it, apparently, then. What happened at UCT, suddenly council got this realization that this is a terrible definition and we have to get rid of this and take some other definition which also has similar weaponization problems. Doesn't make sense.
Yes.
What is further concerning is that the chair himself is during this process is confirming that he is unable to comment on the extent of which the IRA definition has restricted academic freedom. Now, obviously, that is the core issue, the restriction on academic freedom.
Yes.
So the best that could have happened is to open that and for council to debate it. And it doesn't seem like there was a debate around the impact on academic freedom. I see the impact on funding and other
Yes.
issues, but on academic freedom, which is the bedrock of an institution, of a learning institution.
Yes. And the court will recall, I don't have the passage now, that in the answering affidavit, Mr. Arnser accepts that there was no evidence of weaponization of IRA at UCT at that stage.
I think that was also in some instances, the assurance that were given to Donald Gordon as well as the Dell Foundation in the negotiations, either before or after that, because there was some insistence by the Gordon Foundation or the Gov Foundation that UCT should said to prevent anti-Semitism against students and staff members at UCT. And I think those were some of the concerns they had. And I think that was one of the, might be a condition of the agreement.
Yes.
But all of these terms are on the explanation profiled by the chair, and given that these are motion proceedings, obviously the court will have to
Yes.
look at the versions that have been put
Yes.
forward.
Yes. But on these kinds of questions, where the plastic evidence just doesn't play a role, on these kind of questions about should this have been before council, it wasn't. That's not in dispute. The court will decide that it should have been before council. Our submission is clearly this information should have been made available to council. There's simply no reason why not. The chair says, I thought it was right, but that can be tested against whether that was the reason not to put it before council in reality. That can be objectively tested. And also it doesn't answer why no one on EXCO made it available. But as a fact, ultimately, all that matters is that it wasn't before council. That, and nothing else was before council either. The 2019 impact assessment, I can see the court knows the papers incredibly well, so I'm not going to spend any time on it. But if I may just very quickly refer to the 2019 assessment, which is in file 3B at page 790.
File 3B.
790. There is another version of it, but this is the one that's easier to read. And just at a high level skim reading of this, one can see the kinds of things that this report identified. If one goes to page 801, towards the foot of that page,
801.
801. UCT is related to a vast worldwide network of academics and academic structures, including research supporting donor organizations. It's vital that these partnerships and networks be maintained and strengthened, as through them UCT maintains an international position. Then goes across the page. Alumni have in the past made significant contributions. They talk about, again, the status of UCT and what it involves to earn such a status. And they say that strengthening third stream income in the form of research grants and contracts, research endowments, donor funding, alumni contributions, bequests, etc. Premier universities such as UCT found they can only maintain their research and innovation excellence by means of sustainable third stream income revenue. Then at page 809, towards the foot of that page in bold, from a risk perspective, the risk of funding and other forms of support towards UCT by the United States government, by United States government-linked agencies being negatively affected is thus extremely high. And then across the page, again in bold, middle of that page, the ongoing relationship between UCT and German academic institutions. There's a risk that's very high in that regard as well. At 813, talk again about the, just above the middle of that page, reputational damage to UCT. In the case of collaborative arrangements with government agencies being terminated, even if only in the case of Germany and USA, would be immense. So again, this goes to why one of us also look from a reputational point of view at the negatives. At 815, second last paragraph indicates the contributions made to UCT by people with strong Jewish connections or organizations with strong Jewish connections. The termination of these relationships would have a disastrous effect on UCT academically. At 818, in the middle of the page, UCT simply cannot afford its third stream income levels to drop, as it will not be able to sustain its existing research and innovation endeavors. It will inevitably have to cut back on these, which will have a negative impact on its overall national, international academic standing. At 819, below the table, 15% of all UCT donations, gifts, and endowments come from donors or organizations with a Jewish connection. At 820, under that heading, in bold, the risk on acceptance by UCT of such a resolution of losing approximately 57 million rand per annum is thus assessed as high. At 821, this is the most severe consequence towards the foot of that page in bold. The worst case scenario would see UCT lose approximately 660 million rand using 2018 figures, or 55% of its total research contract income. This is from the United States alone. A better case scenario would see it lose approximately 330 million, and then goes on to say, very logically, this would have catastrophic consequences for UCT, to put it mildly. So catastrophic is the mild word here. At 822, and again, this strikes one as something that should have been so to the fore at any council discussion of this. 822, towards the foot of the page, approximately 36% of designated externally funded student scholarships was from sources with an identifiable Jewish connection during the period 2015-2019. Now we know from what Ms. Yach says, that doesn't follow from the fact that you're Jewish that you may not support the resolutions, but also we know that you may not be Jewish organization and you nevertheless be unhappy about the resolutions, because we know it's...
Let's say, sorry, please.
No, nothing further. Yes.
Let's say all of these were put before council.
Yes.
And it seemed the gist of this report was that any anti-Israel sentiment expressed or anything done by UCT as an academic institution is criticized. Would have these consequences. Is that what?
No, with respect, this was dealing with a specific resolution that was being put up then, which was also, call it broadly, a boycott resolution on an institutional level, not an individual academic level, I should stress. So it doesn't follow with respect. As the Lordship pointed out earlier, there was no suggestion on the papers that the Donald Gordon Foundation was going to withdraw funding because of the December 2023 statement. So yes, but I take the court's point that of course but that's what you will have to evaluate. It doesn't follow that you can never do it as a university.
Concern. And I think that was the concern if you adopt the IRA definition.
Yeah.
It being weaponized. In other words, if you should condemn Israel's conduct in Gaza, as a university or as a council, taking all of these figures into account, and if council had done that, the question is would they still have been at risk of losing funding?
Yes, certainly, but then they're weighing these things up.
In other words, it was either And even if they weigh all these things up, which they should have,
Yes.
and I think that is, maybe they jumped the gun here.
That's the point with
They
respect.
jumped the gun.
Yes.
They didn't cross all the hurdles properly. And if they crossed all the hurdles properly, taking this into account,
Yes.
you say, but no, he's not anti-Jewish.
Yes.
In our definition of anti-Semitism does not include our view condemning the conduct of Israel of what's happening in Gaza.
Yes.
And I think that's what they were trying to say.
Yes.
Although they signed the IRA definition. The question ultimately, there was a great risk of them losing funding
Exactly.
of a substantial nature.
Yes.
So it was a question, damn if you do, damn if you don't. But in this case,
Yes.
they did not cross all the T's and dot all the I's.
Yes. Yes, I would submit, Your Lordship, it's not really so at that level of detail. There is a place where Mr. Ahrens has said something about they didn't do a precise calculation.
Yes.
But we're not talking about precise calculation here. They had no idea as a council. He would have had more of an idea, but council generally had no idea as to the orders of magnitude of the potential loss.
Yeah. So your case is not that them condemning maybe the higher definition where it's being weaponized, where there's legitimate criticism against Israel. Your case is the following, and maybe I see something differently in it, but your case is the following, that had they taken this into consideration, placed it before, and the full council debated it,
Yes.
still came to the conclusion, based on principle, based on our obligations as a university, based on our country's values in terms of the Constitution,
Yes.
our obligations in terms of international law. We, as an institution, notwithstanding all of this, will take this resolution.
Indeed. Yes, my lord.
Then we would not have been here.
Absolutely. My lord, this challenge is a process challenge. So your lordship is postulating a kind of no different situation. Well, they may have come to the same conclusion even on this information. We don't know that, of course, because it's quite a bold thing to say, to be faced squarely with just the loss from one donor, 288 students per year will no longer be funded. But they may have come to that, and there may have been a challenge to that, but that's a different challenge. It's not our challenge with respect to
But
lordship
in
has it
respect
right.
but in respect of these proceedings that we are
Yes.
dealing with here,
Yes.
if they had done this,
Yes.
we would not have been here.
Exactly. These proceedings are about what was before you. What did you do in order to ascertain whether this is in the best interests of the university? What did you do in the exercise of your fiduciary duties? Again, not in dispute on the papers that they owe fiduciary duties. Of course, it's what it means when you talk about best interests.
And if they want to get away with it, they should do it properly. That's what you want.
Exactly. These are other people's lives, other people's money. It matters. That's why that's why fiduciaries are so strictly regulated by the courts. You must take into account what are the consequences for other people, and that wasn't done here.
Mr. Perry, can I ask you something following from Judge Peter's question to you about whether Plaston evidence applies? You argued the case thus far on the basis that there was a duty which wasn't complied with.
Yes.
it was put in the papers that this was done deliberately, but I think it doesn't matter if it was done negligently. So accepting that for the moment, can I ask you about the fact that there are, and I don't know if you're going to go there, but there are serious allegations made by the donor that some of the statements in the affidavit, sponsoring affidavit, are false.
Yes.
And that they are, in fact, constitute a lie.
Yes.
Now, is that not a place on every issue, firstly? And secondly, what do we make of that? Because there are some very serious allegations made, in particular about whether or not this was something that was still salvageable, whether it was in the air, whether it was a case of ongoing discussions, or whether it was already too late, and whether or not there was an engagement still between the foundation and the chair, and the chair's account and version is disputed in that regard. Now, are you going to say anything? What do we do with that?
It goes not to the merits of our case, but to costs ultimately. These questions, but it's been a strange experience with respect to this case, because this is the University of Cape Town. There's a challenge, and we say, look, you didn't jump through these hoops, you didn't take these steps, and university, when we thought, looks at this and says, yes, maybe we didn't, and we'll start again. But they don't. It's from the outset. This has been a case where, to use Mr. Perumalsami's term, university hasn't been candid with the court. And I know many of these things that we've identified are in themselves not major, but taken together, it's a quite an extraordinary story when organ of state, as we say in our bench of argument on costs, if I can find that. Paragraph 6, we just quote two constitutional court judgments. A higher duty is imposed on public litigants as the Constitution's principal agents to respect the law, to fulfill procedural requirements, and to tread respectfully when dealing with rights. And the very concise government must do right, and it must do it properly. And this has been a case where this hasn't happened. The most recent example actually comes from the affidavit of Professor Moultrie. If one goes to the rejoinder affidavit in volume 5D, at page 3239, paragraph 280, Mr. Arendse says this: the Council's decision to adopt the Gaza resolutions has prompted several donors to send letters of support to the university, welcoming the resolutions and encouraging the university to stand by its decision to adopt them in the face of this litigation. Those resolutions are at 338 and following. But any fair reading of that is that when UCT, when Council adopted the Gaza resolutions, this prompted donors to send letters to support. That was the trigger for it. Now, Professor Moultrie says, not so. Professor Moultrie says, based on the Vice-Chancellor's report to Council, that is at page 3694 in file 5E, he quotes in paragraph 8 from the Vice-Chancellor's report. The heading is Unauthorized Approaches to Donors. Some of the donors have approached UCT management, indicating they were approached by individuals requesting letters of support for the Gaza resolutions and were not prepared to accede to these unsolicited requests. We're currently instituting an investigation into the matter after one of our major donors expressed disquiet on the matter in the middle of a major UCT proposal review by their governing board. Donor and alumni relations at the university are formally managed and stewarded by the Development and Alumni Department. In the current context, these relationships are increasingly fragile. And then, prompted by that, I did something which I hadn't done, because I hadn't thought to do it, and that was to look at the actual letters from donors that were annexed from 3338. One of them appears to be not from a donor, but from a group of persons who take an interest in Israel, but the ones that come from donors, they all dated July and August 2025. And Mr. Arends's affidavit is also deposed at the end of August 2025. So this bears out what Professor Moultrie is bringing to the court's attention. These were solicited for the purpose of the litigation. They were not prompted by the adoption of the resolutions. Now, I'm not saying this is a big point, but why are we told something like that on oath, which is just misleading with respect?
To divert, you haven't answered the question. The question I asked was, there are allegations made by the donors.
Yes.
The principal donors in this matter.
Yes.
In relation to the DGF Foundation.
Yes.
That what is said in the answering affidavit at paragraphs 248 and I think 228, if I recall, is false, not correct. There were not ongoing discussions.
Yes.
It wasn't a case of this being a possible salvageable issue, not a real risk, not a serious risk. What do we make of that factual dispute?
And there's not only a letter, there is a confirmation, there's an affidavit then
Yes,
also from
it's a
Mr. Applebaum
Quite correct.
confirming this.
It's a serious thing when the donors go on oath to say that the chair of the university has essentially lied under oath. That's what's being said.
Yes. Yes.
Now, what do we do with that?
Well,
Because
as I-
this is disputed.
Yeah.
And Plascon Evans and there are affidavits filed by both the chair and the vice chancellor, interim vice chancellor, who say no, their recollection is otherwise.
Yes, but you'll recall, so the court can look at that issue coldly.
Yes.
The initial response was, we have no recollection. We
Yes,
have
that's
no
correct.
recollection. That's at page 1780.
Wait, 1780.
4C. So in paragraph 7, that we don't have any recollection of being warned at this meeting in clear terms or otherwise about this. Now, that strikes one as a strange thing because this is a very big amount of money. But no recollection is not a denial of the truth of what was said. Then subsequently, and this is pointed out, it's then changed to saying, no, they do have a recollection.
So if there's no recollection, and somebody says it happened, it happened.
Yes, then it happened.
In other words, if you say, I can't remember,
Yes.
you
Yes.
cannot dispute it.
Yes.
That's how I understand the law. You say, I don't remember, and somebody says,
Yes.
this happened, then it may have happened, but you can't remember.
Yes. So if our heads of argument on costs deal with this,
But sorry, it goes beyond cost issue.
yes,
And it's a very serious thing that's happening in these papers.
yes,
The allegations of dishonesty, essentially. And so I'm asking you, what must we do about this, and what's the proper approach? And I think you were saying, well, the credibility of the answering affidavit is an issue because firstly it is said there's no recollection, then it is said there is one, and then you were going to tell us what the recollection was.
Yes.
And then it's a denial, if you can put that.
Yes.
Yes.
And then it's first in the recollection, then
Yes.
after the letter appears,
Yes.
it becomes a denial.
Yes.
The question then is, if you apply Plascon evidence, is that is that a genuine dispute of fact?
No, with respect.
Whiteman head for all of
Indeed.
their cases.
Indeed. We've summarized this. The reason I took you to the heads on costs, we've summarized this in paragraph 49 of our heads on costs and how the version changed. 49.4 and 49.5. And we're saying 49.6, the inconsistent positions. Either chair does not remember or he does remember. And then in the heads of argument, there was an attempt to deal with this I think actually in the affidavit, there was an attempt to deal with this on the basis that he didn't want to say, the Applebaums are, or Mr. Applebaum is wrong, and therefore they were couching it in careful terms, but that's not with respect an answer. If you say, I have no recollection, that's a statement of fact. And with all due respect, we're dealing with a senior counsel of more years experience than I have. You don't on affidavit say, I don't have a recollection, and then subsequently say, oh, I was just couching it in those terms to be polite or something. That doesn't work that way.
It seems to me a bit of a problematic statement because this is, as you point out, about 200 million rand. Now, it's a bit odd that you have this correspondence around the end of April and engagements, quite serious engagement. In fact, the meetings also held with the donors. There's discussions 30 April to 3 May. Then we have the EXCO meeting. All of this is not, it's not just a once-off, one letter. So to say that there is no recollection about one of the central aspects of this entire case is, to me, extremely odd.
And all in the context, my lord, of not disclosing any of this to the council.
Yeah.
So it's not with respect a good story.
Well, the context also, Mr. Fagan, is that the different rememberings and according to Mr. Arendse are justified by the fact that they continued giving hope that, okay, maybe this could work. Yes. And as I understand his explanation, it is that, well, when they engaged with us and sort of promised that this could work, then the need to disclose to council then was mitigated because we kept hoping that it will be resolved.
Yes.
So how does then one read that? Because that's in essence what Mr. Arendse said.
Yes.
And it is true that there has been engagement with them, yes, even after the Senate vote.
Indeed. But that gets back to the question of what must you disclose? You must disclose risk. That risk eventuated. It was cancelled, so it's not it was a real risk, we now know. But there's also another context. The Dell Foundation, which had already said we are not going to be supporting students anymore, other than the ones we're currently supporting.
This is now after the Senate vote.
Exactly.
Okay.
Now that also was not disclosed. And that, even if there was nothing to be done about that any longer, well, firstly, there's always hope to restore relationships, so you would want to keep that hope alive. But secondly, I said it's a warning to the council about what consequences there may be, because there are other donors who may take a similar view and doesn't know. This is all material and relevant information that should have been before council.
Especially where the Dell Foundation, according to the university's version, the Dell Foundation said we're going to continue with the current law and pause and see where it goes.
Yes.
So there's, in other words, a chance that they could continue. You should engage them, and you should tell your council that there is this issue. It can perhaps be resolved or sorted out, but not disclosed.
And again, on risk, if one looks at the private hospital, a massive donation. The Arendt says, well, early stage. There's a bit of a dispute about at what stage was this, but it doesn't matter at what stage it was. It was, we know from the actual facts that quite a lot had been done already. There were working groups, there had been a visit to Johannesburg. But irrespective of that, here was potentially an absolutely enormous gift to the university. Must be disclosed. Has to be put before council so that they know. Yes. And I've taken the court to that email from Professor Fegan to Mr. Arendt, specifically referring to. Lord, I'm conscious of the time. There's obviously a great deal more that could be covered.
Are you going to get to the second resolution?
Yes.
The second resolution.
So the second resolution, on the question,
well, the second resolution,
or similar difficulties are right. Of course, that's not the direct rejection of the IRA definition, so it doesn't go directly to that, but it does go to the general question of what might the consequences be of a resolution not dissimilar from the 2019 resolution, where one had the investigation on impact, in other words, a very severe impact. We say goes further than the 2019 resolution because of the impact on academics in an individual way, but we don't even have to get into that debate. The point is, this kind of resolution potentially had dire consequences for UCT. That wasn't investigated at all.
So can I just go straight to the resolution and ask you, what does it mean? What does it mean you may not engage in relations or continue relations?
Yes.
What does that mean?
No, with respect,
not what was intended. What does it mean? Does it mean that if you have a social connection,
yes,
one academic with another academic,
yes,
you may now no longer be socially connected because that's a relation?
Yes.
Does it mean you may no longer have a wife who is connected because she happens to be part of the object of the resolution? So there's the first problem.
It was very loose and
Very loose. Secondly, it seems to me on a reading of that resolution, it doesn't even ban one-on-one.
Yes.
One-on-one collaborations are not included.
Exactly.
As long as it's not a group.
Yes. Yes.
Or a research group or a network, whatever a network is, and I also have problems with that. What is a network?
And more than that, direct or indirect.
Yes.
How many degrees of separation? This was never answered in their papers.
No, and then it seems it only hits cases where there's an author affiliation. So
yes,
it's only where there's going to be a paper produced. But if there's some sort of long-term project on the go where you are doing laboratory experiments, nowhere near publishing a paper, it's going to take you 5-10 years to get to the paper, but you're busy with clinical trials,
yes,
on a medical project. That too would be hit. So I have great concerns about how does a UCT academic know what they may or may not do, who is hit by this, and what is the broader Israeli military establishment? I think we all know what the Israeli Defense Force, most people would be able to find out, but what is the broader military establishment? So that's also not clear.
On that point, my lord, in our heads of argument, paragraph 105.1, footnote 224,
paragraph?
Paragraph 105.1, page 46 of our main heads on the merits. Council members have acknowledged they do not understand what this term means. I mean, refer not only to Mr. Malsami, but also to Dr. Cardo. And then the chair says broader military establishment encompasses institutions that are formally and presently part of Israel's military establishment. Now, that's as circular as it gets. So that is not helpful. But then also one can see that our learned friends have struggled with it, because in paragraph 330.1 of their heads of argument, at page 136 of their heads on the merits, they say the resolution affects a narrow band of academic collaboration with persons or groups who are associated with the IDF or Israeli military. Now, what is that or doing there? Because Israeli military is the IDF. That's the same thing. So broader military establishment must mean something different, but they don't know, so they don't explain what it is either. So it's entirely nebulous. Plus one has...
It once again, the idea was good, but to get there,
They had to do better.
I don't even if they were lazy thinking or not proper thinking by academics.
And then there's no,
It's really something that, how do you, maybe we as lawyers define something specifically,
Yes.
but as wide as that.
Yes. And the court will recall that in the Senate debate there was talk about amending to introduce the word active.
If I'm thinking about something, if you're thinking about something like, look, you have this person, what about son? He was in the military of South Africa, developed some chemicals that was harmful.
Yes.
He's also, I think, one of the best heart surgeons.
I think he's a cardiac surgeon, exactly. Yeah.
Yes.
Yeah. I wouldn't go to him myself, but apparently he's good.
If it's something like that clearly defined, that no UCT academic may have relations with such a person that develops for at that time developed for the apartheid government certain substances that harmed. I think what was this guy's name? But anyway, so if it was something like that, and if, from my understanding, is that the people are conscripted in the IDF. Some are there, some are not there, and really, speaking for myself, if somebody is involved in the murder of people in Gaza,
Yes.
as an IDF soldier, no university should have any contact with such a person.
Yes.
And that must be the ideal.
Yes.
But it seems some of those guys also have academic view. But how do you, and I think that may have been their problem in clearly trying to understand what to do.
Yes.
And they did not, and how to get to it.
Yes.
But it was couched so wide.
Yes.
Like they said, Afrikaans, so byt soos die heerse genade, so wide that
Yes.
they could not really get to the ideal they were
Yes.
trying to focus on.
And on your lordship's point, how can it ever be rational to say that a UCT academic can't publish a paper together with an Israeli who falls within the suspect category, whatever it is, which is intent on demonstrating that the IDF committed war crimes in Gaza? Now that can't be done under this. How can a resolution be rational that says that a UCT academic cannot publish a paper on tuberculosis with 1,000 other authors across the world, around the world, of whom one is an Israeli person in the suspect category? And how can it be rational to have such a resolution which does not preclude a person in the engineering faculty of UCT from actually designing a better tank for the IDF? There's no author affiliation. You just design the tank. So it's a very peculiarly drafted resolution. It's overbroad, it's under-inclusive, and it's, as your lordships have pointed out, it's vague.
and it was introduced right at the end of the meeting, almost as an aside. It was put and voted upon, no debate. at all. There wasn't a single question put or asked. Nobody interrogated it. There was some talk about what was intended, yes, in the earlier debate. But
Yeah. And I think people will thinking something along the lines of what happened in the apartheid years. You couldn't go somewhere, you couldn't do this, you couldn't do that, because you were aligned with the enemy. I think I was about 40 or 44 when I went to Newlands for the first time, because I was so scared to go there. But the point I'm trying to point is that we had a thing on no sport in an abnormal society. That type of thing.
Yes.
So I think it's something along those lines. Don't associate with that kind of people. But then we need to understand who those people are.
Yes.
We know who some of them are, what they are, but then we must identify the target.
Yes.
Don't go there.
Yes.
Don't attend that course meeting. Don't associate yourself. You know, that type of thing. I was thinking about that. What we had, it's the sacrifice one had to make, not to be identified
Yes.
with certain people and certain organizations and all of that. Wait for the tricameral parliament, that type of thing. But the point of I'm trying to say is that is what they were trying to achieve, but people are so wide.
And particularly necessary because we are talking about constitutional rights here. Freedom of expression, including academic freedom, that one's encroaching upon. You've got to get your wording right. These are not things you can leave vague. It has real impact on real individuals.
But how do you do it when a person stands with, I'm thinking about the Dr. Mendelsohn thing.
Yes.
One foot as academic, doctor.
Yeah.
One thing I might say that anyway, people. 1 foot as an academic, doctor. There is other foot, soldier.
Yes.
That assists in a war.
Yes.
You might have a person that's a professor, I think, and in some sort of field. One day he wears his robe as a professor, the next day he's dressed as a soldier, serving in an army that's responsible for killing of people. How do we? And that was the.
That was.
I think that was the aim to try to do that, but it was the way it was the word was clumsy.
Yes.
Because I think that is actually what they were trying to do.
And along the lines of what your lordship is putting, here would be an instance. Why didn't the council, for example, ask a lawyer in the law faculty or somewhere else, or a few lawyers, draft something that works? They didn't. They start with a Senate debate, and then it's a big debate, and then you comes to council, and there's no work done on this. And I don't know whether it can be crafted, but presumably one can craft such a thing. I wouldn't know what the wording would be standing here, but again, there was no. It was like it was driven by the need simply to get these things approved by council, and no homework gets done.
Yeah, but maybe it's unfair for us in hindsight not criticize it like that. Because you get the person, one day he stands with a gun in his hand,
Yes.
part of the IDF.
Yeah.
The next day he sits in a lab.
Yes.
So maybe it's a bit unfair to but I think that was the problem.
But you'll recall, for example, I think I mentioned it, that in the Senate debate, there was talk about introducing the word active into the definition. It wasn't done in the end, although I think some on council thought it had been done, but it wasn't done. But I don't know how much that would have assisted, but it's an example of something one could have looked at, but nothing was looked at.
in fact, the Senate resolution started off as they didn't have this research groups and letters. They talked about being in association with a member of the IPF.
Yes.
And that was changed.
Yes.
So,
Yes.
but in the context of UCT, from the bibliometric analysis, there's a lot of research, medical research going on between institutions and universities in Israel. Firstly. Secondly, of the studies that were found over 2018 to 2023, there were 3 medically related studies with close collaborations, 2, one in relation to oxygen, I think, and 2 in relation to use of oxygen in disasters, and 2 in relation to hypertension. So it was a medical issue.
Yes.
And there one must be careful because, as correctly pointed out, medical collaboration on legitimate grounds surely cannot be offensive. But of course, if it's used for some wrong purpose, yes. But again, it requires care in the definition.
And just to add, 2 of those papers had more than 1,000 authors.
Yes.
Now, the harm is done to the UCT academic, not to anyone else. They'll find someone to replace that UCT academic, and they'll still publish that paper. But UCT academic now is not a party to this international collaborative medical study, and that's a harm. So the council's imposing harms on UCT academics, may be able to do so, but it must do so in the right way.
But how do you get to the question I'm asking? One day you're standing with your bank.
Yes.
Next day you, and I think that's what I'm trying, because some of those guys are also trying to my understanding of the reading of the paper. And he may be the most gentlest person in, but then he goes to the battlefield the next day.
Yeah.
As a member of the IDF.
Yes.
And how, and I think that's what they want to address also.
Yeah. And I'm afraid it's fortunately not our task to actually draft this for them.
Yeah.
But there may be ways of doing it, you know. But that may be a debate for another day.
I think that to sum up the second resolution, our duty as this court is not to determine the correctness of the decision that was taken.
Indeed.
Whether it was not clever or whatever, it's not our duty. It is the process that we must use with. And as I understand your submission, Mr. Fagan, it revolves around rationality, a lack of consultation, and all the points that are raised in your heads of action.
And the only relevance of the resolutions is we do attack them on the basis of being over-inclusive, under-inclusive, and as your ladyship, please. There's lots more I could say, but I think it'd be sensible, given the time constraints, and I did say I would finish before lunch, that that I leave for reply if it's
sorry. Just on a conceptual basis, so that we approach this properly, the attack seems to be, as far as the first resolution is concerned, the attack is focused almost entirely on the resolution that deals with the IRA Jerusalem Declaration issue.
Yes.
None of the rest of the resolution is attacked. But you are asking us to set aside the decision in terms of which in both resolutions were arrived at. Now I just have a problem with that.
Yes.
If you can deal with that.
So the first resolution includes other things.
Yes.
As the court says.
Which you're not complaining about.
No. We haven't raised a complaint about that. But what we don't know, because this has not been raised by anyone, is whether this is severable. In other words, whether we're not dealing with a resolution where the introductory part leads, as it were, to these things. So if one starts severing, I don't know what happens to this document. UCT hasn't tendered, for example, in the alternative, a redacted version of it. But in any event, procedurally, one would have thought that we all have to go back to see, will council, for example, be happy to adopt a resolution if the process should start again, if this were to be set aside and start again? Would council be happy to adopt a resolution that excludes those provisions? So my submission is not for the court now to do a cherry-picking job on this and say, well, somehow it survives. If we are right in our challenge on the IRA aspect, then it all goes. So that would be our submission.
Yes, I think the difficulty also is there was no debate on these other provisions anyway. Essentially, the entire meeting went around the IRA Jerusalem Declaration and the IDF collaboration with academics. That was all that was
That's the
debated.
essence of the complaint.
Yes.
But you say that that vitiates, you say that if the court should find that there was not done what should have been done and it's irrational, then the entire
Yes.
decision must be set aside.
Yes.
Logically, we can't cherry pick between.
Exactly. I said there's no tender from UCT as an alternative. And I can understand that because this came from Senate. I don't know how Senate would have regarded a redacted document, as it were, and one doesn't know how Council would have responded to a redacted version of that document. So it's all the next round, if there is going to be, if the court should be with us. Thank you.
Can we probably do something about it in terms of Section 172 of the Constitution?
That's a very wide-ranging provision, and the court has all kinds of powers under that. But as I say, it hasn't been before the court so far. It may involve all kinds of examination of documents that this court's not required to do that, and I submit it's unnecessary.
So if you're not required to clear the other resolutions, and I think the main attack against the other resolution was about the lack of candor and not informing the council about the consequences of that specific.
Well, of adopting this resolution
Yes.
as a whole, in other words, but because of the IRA part. But your Lordship actually makes an important point. It is a matter of setting aside the entire resolution because that's the resolution. It contains the provisions that are problematic, but our submission is this resolution should not have been adopted simply. But it's administrative. I mean, this is a review, a judicial review, which means it's not final. UCT can do whatever it wants to do, and we'll see if there's another round in due course. If
Maybe refer them back to them. Referral.
Well, a referral back may be complicated here. We haven't asked for that
So
because they have it anyway. It doesn't need to be referred back.
Yeah.
They can do it anyway. And the other difficulty is they started with Senate. So it's the identical resolution as Senate.
If you say that the 15th of March's decision
Yes.
does make a difference,
Yes.
and you say it remains whether as unlawful and unconstitutional as the first decision. What about the referral? They go back, constitute property, take everything into consideration, go
Yes.
and place everything before everybody. Do
Yes.
your broad consultation
Yes.
that you have to do. Then you make your resolutions.
Yes. But my Lord, the court wouldn't have to refer back for that purpose because UCT has that right anyway. So it's not as though it's not like an appeal decision,
Yes.
or
Right, yeah.
internal appeal decision that comes on review. Then it has to go back to the decision maker in that regard. It's open to
Right.
UCT not to make a decision at all.
You're right.
So a referral back kind of almost imposes on them an obligation to do this again, but they may not want to do this. I say it starts in Senate, so it's a very different situation from
Sure,
normal.
I agree with you.
And then costs, lasting costs.
Yes. My Lord, so our submission is obviously that if we should succeed, that the costs follow the result in the sense that UCT is responsible, but we have asked for something additional. We've asked for punitive costs. This is on the basis of UCT not having played open cards with the court in the various respects that we've addressed. I was wondering, my Lord, whether I shouldn't perhaps leave this largely for reply, just again on the basis of time, but I can just give maybe the headline points on the question of costs. So if one looks at how UCT has gone about this matter, lacking in what we submit is the openness that's to be expected from an organ of state generally, one has then just the way in which Mr. Aronson and EXCO members didn't disclose the fact that they knew to the council about the DGF and about the Dell Foundation. We had an incorrect and incomplete Rule 53 record. lacked the transcript, lacked the VC's report, lacked the Senate resolutions until we called for those. And then we were told that, or the court was told that a record had been filed on a certain date, which was incorrect. It hadn't been filed then. The very poor evidence on the interaction between the Dell Foundation and the Donald Gordon Foundation. Remember, the Dell Foundation also wrote to say, you know, you misrepresented the true position. The evidence about the current Vice-Chancellor's heartfelt plea to rescind the resolutions that was inaccurately presented. I've dealt with Professor Moultrie's correction of the evidence about the letters from donors. This awkwardness of the court being told that council members can request records from the registrar without being told that it doesn't mean the records will be provided. The implication of that was that all they have to do is ask. We're also told that the evidence of Mr. Perumal Sami and Ms. Kelly, Ms. Phelps, regarding governance concerns is unreliable. And then again, Professor Moultrie's affidavit makes it clear from the Vice-Chancellor's report that they are by no means unreliable. And I would ask this question, which I have no answer for. Why is Professor Mendelsohn still suspended as head of department?
Well, that has nothing to do with this.
I know, but it does have to do with this. The UCT has adopted a certain UCT has adopted a certain approach to this matter, and this is punitive. For him still to be suspended is punitive, and that's not what the courts say organs of state do. In addition to punitive costs, we have asked also for personal costs or costs being paid personally by Mr. Arendse and 3 members of EXCO. There were other members of EXCO, but we haven't gone out and joined others who are no longer members of EXCO. Simply too cumbersome a process. That's in the court's discretion, but our submission is that Mr. Arendse, and I regret to say this, I've known him for many years, but he hasn't done well in this case.
And on what basis the other 3 members of EXCO?
Again, a failure to disclose.
Failure to disclose. Okay.
As the court pleases.
Thank you very much, Mr.
As the court pleases, Maleli. I see that it is almost 5 to 1. I'm happy to start, but I'll make a few introductory remarks, but I'm in the court's hands. Perhaps.
I'm going to suggest that you start and perhaps for about 10 minutes, and then we can adjourn just to save time because we're running out of time.
Jewish Board of Deputies. The board is the democratically elected representative of the Jewish community in South Africa, comprised of affiliate organizations representing the majority of South African Jewish religious organizations and civil society. Now, there's no serious dispute, really, as to the board's role as the representative entity of the broad majority of Jewish opinion in South Africa. The issues that this court is called upon to decide bring into very sharp focus a number of very serious and concerning issues. They're concerning to the broader South African community, but they're particularly concerning to the Jewish community. They resonate deeply with the Jewish community, and in particular with Jewish students and academics at UCT. Some of these issues include whether the IRA definition has been used to silence legitimate criticism of Israel, whether there's anti-Semitism at UCT, and if so, what is the extent of it, and whether Zionism is distinct from Judaism, and whether Zionism is necessarily a racist and colonialist ideology. The evidence that the board has put up regarding the global rise of anti-Semitism on university campuses, in particular in the wake of the October 7th attacks, is not disputed by anyone. UCT doesn't engage seriously with the board's evidence of anti-Semitism on the campus. Rather, it seeks to strike out the board's evidence on the basis that it's supposedly irrelevant and prejudicial. Manifestly not irrelevant. It's unclear how the truth can be prejudicial, but I'll return to that issue in more detail. But curiously, though, despite UCT's stance in regard to the board's evidence, it doesn't oppose the board's admission as amicus. Very curious. What I intend to address in my main address are 4 points. I intend to address the definitions, very interesting definitional debate, but we say that from the perspective of Jewish people, definitions are not what this is about. A definition of anti-Semitism is not how one experiences anti-Semitism. Second issue that I intend to deal with in some detail is the rise of anti-Semitism on campuses, and in particular at UCT, and why that's an important issue for this matter. Because in this matter, UCT has not consulted Jewish students, Jewish academics. It hasn't spoken to them about their experience of anti-Semitism on the campus in circumstances where it has adopted a definition of anti-Semitism, which it says partly it was adopted to guide its work. We say that's important. And then the last issue that I intend to address is the connection between Zionism and Judaism in South Africa. The context of that is that the vast majority of South African Jews self-identify as Zionists. And that has profound consequences for how UCT deals with its Jewish students and academics in the circumstances that we've now seen. The circumstances where it adopts a resolution on anti-Semitism without consulting the only people who will ever experience anti-Semitism, the Jews. So if I can perhaps just start with the definitions. We've heard a lot about definitions. There are 3 broad definitions that are contesting for supremacy, one may say so, as to what constitutes anti-Semitism. 2 of them arise in this matter. It's the IRA definition and the Jerusalem Declaration definition. And there's a 3rd definition, which UCT doesn't appear to be aware of, the Nexus Document definition. And each of the 3 definitions contains a large amount of additional context. And most of the contestation around the definitions arise from the contextual matter. The board has put those definitions before the court, not because it takes a position as to which definition ought to have been adopted by UCT, but it sought to place the full definitions of all 3 before the court, because there's an attempt in the papers to set up an artificial binary choice between the IRA definition on the one hand and the Jerusalem definition on the other. The contention is that the IRA definition is somehow wrong and regressive, whereas the Jerusalem definition is a broader definition, it's more correct, and it sets out the parameters of what constitutes genuine anti-Semitism. Now, with respect, the truth is a lot more complex, but actually a lot more simple. Because while the definitional debates are very interesting, and we see that Jewish academics, Jewish people anti-discrimination advocates have grappled and will continue to grapple for years as to what constitutes anti-Semitism. But what one must not ever forget is that anti-Semitism is experienced by people. Jewish people do not experience anti-Semitism with reference to some externally imposed definition. It's their lived reality. It's the conduct directed to them. That's how they experience anti-Semitism. Now, it seems that at UCT, Jews are required to prove that they suffer discrimination, racism, in the form of anti-Semitism with reference to a definition. I don't know of any other group that's asked to do that. And UCT says in terms in its answering affidavit that the council adopts, the resolution that the council adopts, the definition that the council adopts will, and I quote, inform or be incorporated in the university's policies and their implementation, including its disciplinary policies. And that the adoption of what it terms an overbroad definition of anti-Semitism would curtail protected speech of academic freedom. Now, this approach is deeply concerning because it's entirely divorced from what the Constitutional Court tells us. The Constitutional Court in Harkson, almost 30 years ago, tells us that the appropriate analysis of unfair discrimination requires as its primary focus the test of unfairness in respect of a claim for unfair discrimination is the impact on the person claiming discrimination and similarly situated.
I'm
Not
hoping
about
that at
definition.
some point you are going to tell us how all of this is going to assist this court resolve the issues. But for now, we are going to have to take an adjournment.
Let's go, please.
And before we adjourn, it is everyone comfortable with commencing at 1:45, or should I maybe should we say 2?
I think 1:45 is fine for me.
2 o'clock, eh? I'll ask Mr. Bredenkamp to make arrangements with security, or Mr. Mbongo to make arrangements with security so that you do not encounter problems when you come in before 2. All right? Correct.
I think that.
It looked like they weren't expecting to be caught. Enough was expecting to be caught. He says, no, what about this? What about this? What about that? No, no, I'm telling you everything. Yes.
The necessary context for understanding why the board says that it was necessary for the council, before it adopted the resolutions, to take into account and to consult with the views of Jewish students and academics about their experiences of anti-Semitism on campus. Because when you adopt a resolution about anti-Semitism, you adopt a resolution that goes to what you say as UCT is going to inform how you deal with anti-Semitism at a policy level, including at the disciplinary level, but you don't consult with the very people that experience anti-Semitism. It's like adopting a policy on disability access and not speaking to a single disabled person. And UCT says, well, it didn't need to consult because the right to consult is narrow. It accepts, it's not in dispute, that it didn't consult with Jewish students. That's not in dispute. It says it consulted with academics because it consulted with the Senate. Well, with respect, the Senate might be a body, a representative body of the broad general academics at UCT, but they are not a representative body of Jewish academics. It amounts to UCT in effect saying, we consulted because we consulted with ourselves. It's not good enough, we say. The evidence that the board puts up demonstrates that both before and after the resolutions were adopted, there was a climate rife with anti-Semitism at UCT. When UCT had the IRA definition, had adopted the IRA definition, there was strident criticism of Israel. Contrary to what UCT says, the IRA definition didn't shut down criticism of Israel. There was a vibrant culture of criticism of Israel, both before and after the different definitions were adopted. The evidence that the board has put up, which is uncontested, demonstrates that since the October 7th attacks, there has been a marked increase of anti-Semitism on university and college campuses across the world. That's not disputed by anyone. Often, the rhetoric is couched as anti-colonial, anti-apartheid, anti-Zionist, but very often that shifts into anti-Semitism. Not always, but very often. And that's the evidence globally of what's happening. Academics, Jewish students on campuses around the world are facing an onslaught of anti-Semitism. That evidence is not disputed by anyone. And what the board says is that UCT, unfortunately, is not different. That the same thing is happening at UCT. Contrary to what UCT says, the UCT's complaint about the board's evidence of anti-Semitism on the campus is met with, well, we want to strike it out because it's apparently irrelevant and it's prejudicial. Well, with respect, they don't effectively answer. They don't say it didn't happen. They don't say you got the facts wrong. They say we don't have to answer it because it's hearsay. Well, the hearsay complaint has been cured by the delivery of the signed affidavits, and for that we do apologize. That was an administrative error. But in any event, the issue of hearsay is neither here nor there, because the role of the amicus is to put up context for the court. That evidence is now an affidavit before the court. The relevance is for the court to decide in the light of all of the issues, having heard all of the submissions, and as Your Lordship presiding indicated, the weight to be attached to it is something that the court will determine. But what is clear is that despite UCT having committed to adopting the IRA definition when it signed the contract with the Donald Gordon Foundation, criticism of Israel was prevalent at UCT. UCT doesn't deny that effectively.
What can you do? You can only work with what was at the time the decision was taken.
Is that if one looks at the conspectus of evidence, both before the new resolutions were adopted, and after. Without UCT understanding whether there is a climate of anti-Semitism, what anti-Semitism actually looks like on the campus, it can't effectively deal with anti-Semitism. And it cannot put up a resolution that says our current definition shuts down criticism. We're going to adopt a better definition because that better definition is going to help us deal with a problem that we ourselves don't understand. If you don't do the investigation, if you don't speak to people, what are you doing? How do you know you need to adopt a new resolution?
They gave a definition, anti-Semitism. They gave a definition and adopted a definition of anti-Semitism without having properly consulted whether the one is right or whether the one is wrong. That is in essence your complaint.
And we're not saying that Jewish students and academics are the only people that needed to be consulted. South African Jews for pre-Palestine also have been consulted because they've got a different view. We don't know if they consulted with them or not, but they certainly didn't consult with us. You don't understand the nature of the problem. It's unclear how you can adopt a policy to try and deal with the problem. That's really the nub of the issue. And we see in the response from the Vice Chancellor in his rejoinder affidavit how UCT in fact deals with these things, because he says on the one hand that anti-Semitism must be taken seriously and addressed robustly. Says that in his rejoinder affidavit, volume 5E, paragraph 18. And that's page 3514. 3514. But in the very same breath, he dismisses the concerns of anti-Semitism at UCT, and he says that it's exceptionalizing one form of discrimination above others. And that's in the same affidavit, again, volume 5E, paragraphs 18 to 20, page 3154 to 3514 to 3515. And he expressed that very same sentiment in a meeting with the board representatives. The board said, well, we don't expect you to exceptionalize anti-Semitism, but what we expect and what we're entitled to ask for, and in fact, I would say demand, is that anti-Semitism is dealt with in the same way as any other form of discrimination. Take it seriously. Consult with people. When complaints are given to you, investigate them properly. The Vice Chancellor says, well, he doesn't engage with the complaint. In fact, he lays the blame at the foot of the students and the academics for not following a proper process. Now, the board's evidence shows that while UCT's reporting mechanisms and its channels are good in theory, they unfortunately just don't work, at least insofar as anti-Semitism is concerned. The experience of UCT students and academics is that they are reluctant to follow UCT's channels because of the risk of being intimidated and singled out. We see that in the evidence. And that's why students and academics say they go to either the South African Union of Jewish Students or the board to channel their complaints, because they feel that that's a more effective way of dealing with it. That's an indictment on UCT. That's what the evidence demonstrates. And just some of the examples of the differential treatment. UCT permitted Palestinian Solidarity Forum to host an event at which Hamas and Palestinian Islamic Jihad representatives were permitted to address students. But it denied SOJUS, the South African Union of Jewish Students, permission to host an Arab-Israeli Christian journalist on campus, presumably because he's supportive of Israel. And the board says that, well, that's demonstrative of a betrayal of the rights of Jewish students. All they want is to be treated equally. If you allow one, you must allow the other. Whether it's right or wrong to allow one or the other is neither here nor there. But if you're going to take a stance that certain people are not permitted on the campus, well, explain why, at the very least, other people are allowed. In particular, where people raise complaints, legitimate complaints, that the people that you're allowing to come on campus have deeply anti-Semitic views. They may be right or they may be wrong about that, but what you can't do is what UCT did, which is to completely ignore the complaint. Now, the evidence shows that Jewish students and academics at UCT are targeted not only because they're pro-Zionist, but because they are both pro-Zionist and Jewish. And that's exactly what the Constitutional Court in Masuku said constitutes discrimination that is not permitted under the Constitution. And a lot has been said about, this is all about anti-Zionism and to try and distinguish anti-Zionism from Judaism. I want to preface my remarks by saying one must remember that in 1939, before the start of World War II, the global Jewish population was 16.5 million. For context, in 2023, the Jewish Agency for Israel estimated that the global Jewish population is 15.7 million. Just think about that for a moment. As we stand here today, there are fewer Jewish people alive than there were before the Holocaust.
But fortunately for us, we do not have to make a decision. It's Zionism or Judaism, but it's providing the context.
Yes, Malik. Difficult decisions. These are debates that have raged, and they're not for this court. But there are important pieces of context which UCT should have considered. And the failure to consider how Jewish students and academics experience their connection to Israel is an important issue that UCT should have considered.
And this is not an issue, it's an issue that could have been easily dealt with and consulted.
Absolutely, my lady. Absolutely. Absolutely. Consultation is key. Talk to people. Whatever you decide is a different story. You can come to whatever conclusions you want, but you can't say that your resolution was adopted appropriately, having considered all of the relevant facts when you didn't consult with people affected by your resolution.
They didn't even consult this amendment. There's very well placed to help them with the information.
Absolutely. Absolutely. He was a signatory to the Jerusalem Declaration. They could have spoken to him and asked him about these issues. They've got the Kaplan Center.
Donors considered him as a very well-respected member of the community.
Absolutely.
He was the first person they could have consulted.
There's no explanation, and that's the difficulty, and it's really very difficult to understand. Why not just talk to people? What are you afraid of hearing? One must always ask that question. You're an organ of state, you're working with public money, you're making decisions that affect hundreds, if not thousands of people, and you just don't want to talk to anyone. It's very, very difficult to understand. And some of the important context is that the Kaplan Center's 2019 community survey provides critical insights into the relationship that South African Jews have with Israel. The vast majority of South African Jews identify as Zionists. 92% affirm that Israel is their ancestral home of the Jewish people. 89% have visited Israel at least once. Nearly 1 in 5 have visited more than 10 times. 66% report a strong attachment to Israel. An additional 24% report being moderately attached. So together that makes 90% who feel an attachment to Israel. By contrast, only 4% of the respondents in that survey said they had a weak attachment to Israel, and 1% described themselves as having no attachment at all.
I'm just thinking, if council were to take position, let's say, affecting black students, would council need to consult with all of the black students or at the institution? Is that how I should read the submission?
To adopt a resolution on gender discrimination. Who are you going to talk to? It's like one of my colleagues said, it's like a group of men sitting in a room and deciding on a definition of sexism and giving it to the women and saying, there you go. My lady, when we talk about consultation, it doesn't have to be every single person that you consult with. But at the very least, you've got to make an effort to consult with a representative body. It's impossible to consult with every black student, for example, but there will be organizations on the campus that represent interests. And you speak to those people and you find out what their views are. And as I've said, ultimately, it's not about where you come down on the issue. It's about the process you follow. And if the process is followed because you don't have the information, you don't take into account relevant facts, well, then we know what the result is. Yes, my lady. I see I'm running very, very close to my time. So we've made detailed submissions in our heads of argument. We stand by those submissions, but just in conclusion, lady, what we simply say is that the evidence shows that there was no consultation. The evidence shows that there's rampant criticism of Israel both before and after the resolutions. And we say that that's why it was important for UCT to consult. UCT needed to consider the views of people affected directly by the resolution, and its failure to do so renders the resolutions reviewable. No, absolutely not. The board doesn't say this definition is right or that definition is right, but it says talk to us at the very least about the definition that directly affects the only people who will ever experience anti-Semitism. Unless the court has any further questions, those are my submissions. I think I've gone a few minutes over my time. As the court please.
Lady and my lords, what I propose to do with the remaining time is to address 3 of the topics that are on my schedule, and then to address the remainder tomorrow morning, if that is in order. The first one is just a short summation on the test for review. And I understand that I will be traveling ground that is familiar to the court, but it has become necessary to do that in the light of the submissions we had from our colleagues for Professor Mendelsohn. The second topic is just to explain why the resolutions were taken. There has been a lot of debate, but what is forgotten is Palestine. A lot of discussion is about Israel, not about Palestine. But the resolutions were taken in solidarity with Palestinians. So I'll deal with that in my second theme. Both of those will be short, but they are important to set the context. The third one is to deal with what has been characterized in our heads of argument as mootness, which is the character of the resolution is a living resolution. It is subject to UCT's own revision. And I want to show on the papers where those revisions have been and what the resolution has been and what facts were known at each stage of the revision. That will include these topics about non-disclosure and the risk and the impact, which were the main themes discussed today. And I'm going to show to the court that contrary to what has been suggested on behalf of Mr. Mendelsohn, every little fact, every little detail was known by the council, certainly in July 2024, and it was all disclosed by the 15th of March 2025. Everything you can think about is known by the council, and at each stage, they have reaffirmed the correctness of their resolution. Why? Because these are not resolutions about Palestine. That's what they are talking about when they're saying this is a profound moral question. It's a profound moral question. That is how they describe it. So let's start then at the beginning of what I want to deal with this afternoon, just to explain the test for review. This is not a case about administrative justice. Justice Henny was correct when he pulled the latest edition of Penfold and Hoekstra. This is a case about legality. It's a section 1C of the Constitution. Now that has material consequences to how the court approaches its job of review, particularly on the one ground of rationality and the so-called failure to take into account relevant circumstances. If I can ask the court to have regard to paragraph 189 of our heads of argument. We've taken an extract, sorry, my lady, I think it's 129, sorry, not 189. We've taken an extract from the judgment of the Democratic Alliance in the Constitutional Court. It's the so-called Simelane case. We've cited the paragraph in full, and it's paragraph 39. It has been affirmed in a later judgment by the Supreme Court of Appeal called Scalabrini. So this is how they explain rationality. And it's very important because 129 of our heads, my lady, yes. And it is paragraph 39 of the judgment, 129 of our heads. It says the following: if in the circumstances of a case, there is a failure to take into account relevant material, that failure would constitute part of the means to achieve the purpose for which the power was conferred. And if that failure had an impact on the rationality of the entire process, then the final decision may be rendered irrational and invalid by the irrationality of the process as a whole. The court knows that. But here is the point that needs emphasis. There is therefore a three-stage inquiry to be made when a court is faced with an executive decision where certain factors were ignored. The first is whether the factors ignored are relevant. So tick. The second requires us to consider whether the failure to consider the material concerned is rationally related to the purposes for which the power was conferred. And the third, which arises only if the answer to the second stage of the inquiry is negative, is whether ignoring relevant facts is of a kind that colors the entire process with irrationality and thus renders the final decision irrational. So when you are engaged in a legality inquiry, this is different to an inquiry into Palger rationality. It's totally distinguishable. So this is the only instance in which you are able to set aside a decision on the grounds of the failure to take into account relevant considerations, on the grounds that they render the decision irrational. Because remember that under legality, you really have two broad grounds. One is authority. Do you have the power under the Act? The applicant simply does not come home on authority. The council has the power to pass these policies. Then you have a second basis of challenge, which is rationality. But because rationality as a standard of review pays due deference to the decision maker because they have been assigned by law to make those decisions, rationality is a very narrow scope for intruding into the decision. It's different to Palger, which is broader than rationality. And so you have to take a very narrow line in order to set aside a decision. Everything they have said today simply ignores paragraph 39 of the judgment of the Constitutional Court, totally ignores it. They never ask the second stage, they never ask the third stage, they only ask relevance. Well, yes, in order to answer rationality, they have to answer three questions. And the first question is relevance. The second question is relationship between the material ignored and the provisions of the statute. And the third one is whether that which was excluded has rendered the entire process irrational. Yes. Now, the only part they have answered in their pleadings and in their heads of argument is the first part, that the information was relevant. They have not answered the second and the third. And this is the fundamental problem with their misunderstanding of how the rationality inquiry applies in section 1C of the Constitution. They have conflated it with section 6 of Palger, as if we are dealing with administrative action. Now, this problem, Justice Henny, permeates the entire debate. It actually gets very confusing because even when it comes to consultation, I don't want to speak about the Amicus because they are running a case that's not pleaded even by the applicant. But even the applicant's own argument, when it comes to consultation, they assume that this is a case about procedural fairness, whereas there is no right to procedural fairness under the principle of rationality. They talk about Professor Mendelsohn having a right to be consulted. He has no right to be consulted. He doesn't possess any special knowledge on anti-Semitism. He has no right to be consulted. The only parties that have a right to be consulted are the members of council. And the council is a multi-stakeholder body. It has academics, it has students, it has workers, it has ministerial appointees, it has donors. Those are the people that have a right to be consulted. If the decision had been taken after excluding a member of council, it would be procedurally unfair. So procedural unfairness is not a ground of review under section 1C of the Constitution, which this case is about, section 1C of the Constitution.
Is that also the Masetla case and the
Law Society case?
Law Society case?
In fact, in this division, Taumana versus Mbete, Bel Porto.
Started out also, but what's the other guy's name that is the director?
Simelani, yes.
Exactly. Masetla was the guy that was appointed,
Yes.
And the president fired him, and the question, yeah.
Into process under rationality is what is called procedural rationality, where there is a unique group of persons that possesses special knowledge or special experience. In Scalabrini, you want to close a refugee center, but you have failed to take into account the views of the refugees. Professor Mendelsohn does not say in his founding affidavit that there is a group of persons that has special skill or special impact that are affected in the founding affidavit. He says that the academics should have been consulted, but the academics were consulted. Professor Mendelsohn was present at Senate. He made a long speech at Senate. The academics were also in the meeting of council. They were represented by the two representatives of Senate. They were consulted. Everybody who is a constituent member of council was consulted. So that again is
not have been repeated by council because it was already been executed.
So council is an executive body.
Council is an executive body, yes. It's,
The
well,
executive
it's actually
decisions.
called governance, but yes, executive, yes. We would
Based on
accept
the
it.
Free State case.
Yes, it's clear from the Free State
Free
case.
State case.
Yes,
They make polycentric decisions,
precisely.
decisions that fall within and based on policy. They don't execute like an organ of state having to do something and having to give reasons as to why they do something. Similar to when the president of cabinet acts, and that was some sort of a profound decision by the Constitutional Court in that regard, the University of Free State case in that regard. So, and that's what I grappled with in this case right from the beginning and after I went through this. The difference between and a party review, rationality and a rationality review, which we are dealing with here. So, but I'm not going to interrupt you any further.
So just to come to close this topic, the court has to be very, very careful that it does not import PAJA requirements into a legality review. There has been a lot of confusion introduced by Mr. Fagan, because not only does he introduce PAJA requirements, he also introduces correctness requirements. I don't like this definition. I prefer that definition. That definition, you have not proven that it doesn't work, and therefore this and that. Those are not inquiries for a court that is concerned with legality. Legality is a very simple exercise. The connection between means and ends. That is what the rationality requirement is. So it's a narrow test and it's light touch, and it gives effect to the fact that we have a body that has been selected by statute to make these decisions. And we may not appropriate to ourselves superior wisdom. We think they should have done it better. We have a better way of doing it. That is just wrong. We've cited all of these authorities from paragraph 41 to 45 of our heads of argument that draw these distinctions. Now, the second, then I need to finalize Rautenbach. The court will remember that we were taken to school on the Rautenbach judgment. Now, that judgment of Rautenbach, Your Lordship, Justice Henry, was correct when you pointed out that this was a PAJA decision. Now, then you were told, no, this was under rationality. But the point is this: if you go to page 137 of that judgment, at paragraph 67 and 68, where they are dealing with consultation, which is what was read out supposedly to show what perfect consultation.
Of the SCA.
The Supreme Court of Appeal,
Yeah.
the judgment by Smith J.A.
Yeah.
Now, just look at paragraph 67. Look at the heading. It's called procedural fairness. Look at the following paragraph, paragraph 68, which is an evaluation now of the procedural fairness by reference to section 3 of PAJA. So everything you see in this judgment is about PAJA. It's not about legality. So again, it's inapplicable. The same as the judgment in all pay. Remember, the court was read out paragraph 27 of all pay, which says that sometimes when an administrator doesn't consult, it shows that they have something to hide. Now, every administrative lawyer cites that paragraph, but today it's totally irrelevant. All pay is about a tender, and the decision to adjudicate and award the tender is administrative action under PAJA, and it is to be reviewed through the prism of PAJA. So everything you hear about all pay, it's irrelevant. Strike it out, because this is about legality, not about procedural fairness. Everything you hear about Rautenbach, strike out. It's irrelevant. This is about legality and not about PAJA. Federal, indeed. Federal, in fact, I think maybe Justice Henry had that case in point, because Federal was really the beginning. It's a 1997 judgment. Yes. Precisely. So now that we've cleared that confusion out, we can then go to the second of my topics, which is why did the university take these resolutions? The first thing that's crucial there is to look at the statute, which is the Higher Education Act. My learned friend said the only thing that's relevant in the Higher Education Act is Section 27. We agree that it is relevant, but we disagree that it is the only relevant thing. What is also relevant in the Higher Education Act is to understand its goals, which you will find in the preamble. It's very crucial to just emphasize some of the clauses in the preamble. What the Higher Education Act intends to do is to redress past discrimination and to ensure representativity and equal access. It is to promote the values which underlie an open and democratic society based on human dignity, equality, and freedom. It is to respect and encourage democracy, academic freedom, freedom of speech and expression, creativity, scholarship, and research. It is to pursue excellence, promote the full realization of the potential of every student and employee, tolerance of ideas, and appreciation of diversity. The same goals underlie UCT's own code of conduct. They have been I just want to get that code of conduct. Oh. Yes, I've got it now, my lady. It is at 1281. Yes, thank you, Justice Henry. Now, I wrongly accredited your assistance to the wrong judge. Now, so the first clause is the council. It governs the university and it must ensure effective institutional governance. But also it is constituted and mandated by statute and the Higher Education Act, which is why you always have to read it together. And it has the responsibility for the affairs of the university. It also determines the nature and scope of the university's social responsibilities, protects the institutional autonomy, upholds the academic freedom of its members, and deliberates on the nature and role of a university. But also, it does other things. When you look at I want to see the statement of benefit. Yes. That's 1285.
It also says, in performing its tasks, the council commits itself to acting with the duty of care and skill that is owed to the university.
Precisely.
So there's a fiduciary duty, I think.
No, I accept that.
You accept
No, we
that?
totally accept that. Maybe Justice.
In exercising that fiduciary duty, would it be correct to say that those members of council who sit in meeting must make sure that they must put before the council such information as may be necessary, relevant, and appropriate for the council to arrive at the decisions that it needs to make in governing the university?
No, that's goes without saying.
That is so, and you go to the DA test that you cited on page page 53 of your report. Yes, yes. So the question is, were there considerations that should have been put, that were relevant, applying the DA test, that members of council should have put? Were they rational, relevant to the process? And if they were not put, how do they affect the decision?
How do they affect the ultimate decision?
Yes.
Precisely. No, I think we are actually asking the right question, because I am going to demonstrate that on that factor 3, they ultimately do not affect the rationality of the decision. And I'm supported on that by the fact that the financial consequences were known, but I'm also supported by the decision on the 27th of July and the decision on the 15th of March 2025.
Those two decisions, both of them were neutral as far as what was decided in June 2024 is concerned.
We're neutral.
So, well, I'm saying that they didn't change.
No, they were not neutral. They supported them.
They may have supported them as a statement of support, but how does that change the decision?
No, they don't change. They affect. Remember that
Yes,
both of those were pursuant to section 20, subsection 5, subsection H of the institutional statute, which is a special power of the council to reconsider its own decisions, which does not exist anywhere else. There's a special power to reconsider your own decisions. It's section, it was actually the registrar who gave me the section during the adjournment, so maybe she should. It's section 20, subsection 5, subsection H, yes, of the institutional statute. I think it's H, yes, H, yes, which is a special power to rescind and reconsider your own decisions, which ordinarily, if you've taken a decision, you'll be bound for it until it's set aside by a judge. Yes.
In administrative law, exactly. An organ that makes decisions. It's a special power given. And that power derived from where? From the
institutional statute.
In institutional statute. Okay.
So now that is a very, very important power, because it means if you make a wrong decision or you make a decision without taking into account certain considerations, you can self-correct, which is a power that does not exist in public law generally, unless it's been given to you by statute.
Witness, we still look at other crowd, but what do we have here? And I thought there must be something in it more than that. So it's derived from that.
Simple answer is there is an institutional statute provision for self-correction. Now, so I come back then to, because I don't want to say I'll answer you later, Justice Chair, I must answer you now. I come back to the question you've asked. Because there is a special power to self-correct, and when, especially the decision of the 15th of March, I want to show you what they knew at that point. What they knew So if I could take the court to the answering affidavit, there's a couple of parts where this is relevant. So in the answering affidavit, it starts at paragraph 216. Yes.
Let me just go to the.
It's volume 4A.
Or as I'm told, it's actually the rejoinder, not the answer. It's at page 3222. Yes. Yes, that is Mr. Kessler. Yes, it's apparently it's 4D, 5D. Yes. Yeah. Don't know. It's fine. 5D. So at paragraph 216, it is stated, as Mr. Perumasalmi acknowledges, the council has received new information about the financial consequences of the resolutions. Despite being aware of these consequences, including the cancellation of the DGF agreement, it has reaffirmed its support for the Gaza resolutions, most recently by voting against the rescission of the resolution. When the council took this decision, it had also received all of Professor Mendelsohn's founding papers. So what we have today, these papers we have today, everything about DEL, everything about DGF, everything about the academic impact, all of those things were before the council. On the 15th of March 2025. Yes, they were before this council.
You are saying the initial decision is off the table in terms of the provision that the council can self-correct a decision. In other words, it's as if it had been set aside by a court.
You have a power to self-correct if there is a problem.
In other words, they rescinded the decision.
Well, they reconsidered it because they refused to rescind.
They reviewed the decision, and what they then did is then there was enough, all the information were placed, all the information, at that stage it was known at that stage, with the for the foundation that would on the funding, the hospital is not going to be built, the Dell Foundation is not going, all of that. And then they went ahead with that in mind, with all that information before that. So that was a totally new decision. The previous decision then, according to you, and according to what I understand from what you're saying to me, can therefore not be reviewed before this court. Yes, because it doesn't exist anymore.
Certainly, insofar as the court, no, what I'm saying, I suppose, is somewhat more modest than that. What I'm saying is this. What? I don't understand. I really don't understand. What I'm saying is somewhat more modest, because what I'm saying is the ground of review that is premised on the absence of critical information is totally irrelevant, because that information is before the council. They have considered it twice and they have decided to reaffirm their decision, exercising their special power under section 20, subsection 5 of the institutional statute. So there is no review that is capable of being granted on that ground. And hence the heads of argument characterize this defense that it is an academic question. It's an academic question. It comes back then, Justice Sir, to what we were talking about. Today, as we speak, whatever the mistakes, and I'm not conceding there are any mistakes, whatever the mistakes of the 22nd of June 2024 have been self-chored by the council. And Leonard Friend said this is not pleaded. I don't understand. I've just shown you the paragraph where it's expressly pleaded. Now,
the mistake,
especially this mistake
or the particular
Alleged.
mistake, which is alleged absence of critical information. So whatever happens, then every other mistake we can speak to.
if there is a new mistake.
If at all there is.
But this ground, we've got to always remember that it has served before the council with everything we've been dealing with today, and the council has reaffirmed. Now, why? Come back to where I started. This is a profound moral question of the day. It's truly a profound moral question of the day. When Professor John Ugart wrote an opinion for UCT, he called this a crime of crimes, a crime of genocide. We have not spoken about the G word today, but this is what morally moved UCT to act. And UCT is the only university in the country that has the moral ability to call out the conduct of Israel. No one else has the legitimacy to call out the conduct of Israel. It's only UCT. This is the #1 university in Africa. Its word carries a lot of weight. It decided to speak out when everybody else was cowed into silence. And that is why it also couldn't close the debate on the issue, because it recognizes that the issue is not a universally accepted one. And that's why it kept debating it. A councillor who says, I want it rescinded, they put it back on the agenda. They say, a year later, I want it rescinded, they put it back on the agenda. Reflecting the dynamism of the council decision-making process, as opposed to the irrationality. It reflects the dynamism. If you want it reconsidered, we consider it again. But today, they know the financial consequences. The accusation that they have become irresponsible, etc., because they didn't know this, that's untrue, factually untrue. They know it. And they have made a choice that despite this knowledge, we are going to put the plug of UCT, the badge of UCT, behind calling out the conduct of Israel in Gaza. Because why? We are the only one who can do it in Africa. And that takes me to this second topic. I moved from this so that I could answer Justice Sher, but I don't appear to be avoiding him. When we look at the values of UCT, we find those at 1286. We see the academic values, but we also see something else called institutional culture. The volume 4A, yes. Yes. So at the opening part of 1286, this is what they say about UCT. As a public university in Africa, we fully embrace our African identity. We are committed to utilizing our resources to widen educational and social opportunities, enhance the quality of life of individuals and communities, build an equitable social order based on respect for human rights, and advance the public good through knowledge generation, teaching, and active engagement with key challenges facing our society. South African, when you look at who is the society, South African, continental, and global. UCT is committed to promoting human rights, not only here, but in Africa and the world. Professor Mendelsohn says, why don't you speak about Russia? Why don't you speak about somewhere else where there is a human rights problem? Well, he must put the item on the agenda of the council. This case is about Palestine. When you look then after values, you've got academic values and then institutional culture. Inclusiveness, embodying respect for cultural, religious, linguistic, political, and other differences, and acknowledgement of the value of diversity in society. fairness, consistency, integrity in both academic and other work, in all personal and institutional relationships. Build on the best of UCT's legacy. That's to put a pause on this. What is the best of UCT's legacy? UCT is the university that called out apartheid in the 60s. When all other universities went along, it was this university with its council at that time that branched out of the general university support of apartheid, while interrogating the historical values and assumptions that inform our institutional culture and the academic project. Refrain from speech or conduct that demeans or humiliates people. Now, Palestine is the greatest moral dilemma facing the world today. Many people don't want to speak on Palestine, either because they're afraid of America or afraid of this, but no one wants to speak on Palestine. UCT decided to speak on Palestine. When it did so, let's look at what was going on. It was the height of the genocidal campaign. Not me who says that. The United Nations says this is a genocide. The International Court of Justice says the acts are plausibly genocidal. Now, Professor Mendelsohn says, no, he listened to a former judge speaking on BBC who qualified it and said it's not quite. The fact of the matter is that the ICJ has given 3 orders in which it is explicit that there should be no further military incursions on Gaza. Gaza was described as the worst place on earth for children. It is equivalent to hell for children. It has starvation induced by Israel. People are dying not just of guns and bombs, they're dying because they are hungry. Why? Because Israel has decided it will not allow humanitarian aid into Gaza. Infant mortality is higher than it was during the World War II. Of course, UCT can't solve this. Nobody asked. I heard my learned friend talking about how these resolutions will have no impact on the actual conflict. It would be naive to think that it would. But that does not prevent UCT from expressing a statement of moral solidarity with the children of Gaza. And so that is why we say, if there is anyone in Africa with the moral authority to say something about Gaza, it is UCT. Now, it is impossible to pass a resolution of this kind that would be free of defects, that would be perfect, that would have no point of criticism. It is impossible. This is not a statute. It's a policy resolution. It's an instrument to organize the policies of UCT. But the substance of it, the goal that was being sought to be achieved, was a goal of expressing the indignation around the genocidal campaign. These issues I have been addressing all appear in the transcript when this matter was debated. The court will find the transcript at page 657. Take, for instance, page 673, Speaker 14. Chair, Speaker 14 says, I am not going to go into detail I think that Speaker 13 has painted the issue around Gaza very substantially. What I am going to point out that it is no longer limited to Gaza, because a whole lot of what is going on in Gaza has also moved into the West Bank. And we know the story of the settlers in West Bank, very, very violent settlers. And the destruction of villages, he says, which is what I was talking about. Every single day, there is more destruction of villages. And every single day, there is carnage at universities, in the city and in the West Bank. So I really think it behoves us as an institution with the kind of reputation and history that we have got to support this resolution. Let me stop there. Then, the rule of law, page 675, Speaker 1. Well, what I did not focus specifically on that part of what the ICJ found or said, but I was thinking more of saying something along the lines that we have always been committed to the rule of law. We have always been committed to uphold the values of our Constitution. And one of them is very important, and that is to uphold international law. And there has been a ruling by the ICJ, whether it is in that form or another that you indicated, but clearly the ICJ has indicated to Israel, both in its original ruling and subsequently when the South African government went back, that what is happening there must stop. You go on, page 677, Speaker 13. Chair, while I respect Speaker 16 as a lawyer or an advocate, from John Dugard, who I expect is a jurist, one of the preeminent international legal jurists, and his opinion speaks about genocide as the crime of crimes. And he says Israel has failed to carry out its obligations imposed by the International Court of Justice. It continues to commit plausibly, it should be genocide in Gaza, which is very different to what Speaker 16 is saying. Now, these things I have been trying to show the court where the motivation are all covered in the deliberations, including the fact that UCT must pass the resolutions in the light of its history and reputation. So this is what informed them when they met on the 22nd of June. That's what motivated them. Now, of course, it is true that in that discussion, other speakers said there would be financial consequences to this. But ultimately, the decision was, we will bear them. We will bear them because we cannot square up those financial consequences with what we have to decide today. I hear, my Lord, I was actually taken aback listening to this, but you know, in court, people just say anything. I hear Mr. Fagan saying they should have done a cost-benefit analysis. I was just astonished at that submission. A cost-benefit analysis on genocide. I mean, I just do not understand what this cost-benefit analysis is intended to achieve. The speakers are clear there that what they have to pronounce themselves, not that they are capable of stopping, but they have to put the name of UCT in support, right? Is what has been described as a crime of crimes. That's what they want to do. And then you have someone many, many, many years after saying, well, do a cost-benefit analysis. They knew there would be a problem. They knew that there would be sponsors that would be attached to one definition or against this definition. They knew that. And what they decided is that we have to use the badge of UCT to support the children of Palestine. Yes, because it's in the transcript what I'm saying. Yes, that's this. No, the speakers there, yes, all of them that were in the meeting, because the speakers, they said, what about the financial consequences? Yes, yes, precisely.
I'm then afraid not enough has been included. This, it will be premature.
Yes, but
So there were those.
absolutely accept what your leadership is saying. But I'm saying what that proves is that in that meeting, that concern was raised. Despite that concern being raised, the resolution was passed. So,
Following what Judge Ndito asked you, I'm not sure that what you're saying is correct. Mr. Perumal Sami, who's an advocate, says that he was, the first time he found out about the donor agreement and the value of the donor agreement was when he saw it next to the answering papers. This is now how much he knew. He didn't have any idea. There was no disclosure of that.
I've never suggested that the donor agreement or the amount was there. The papers don't show that. The papers show that they knew that there would be financial consequences.
Maybe
They
400
didn't
million.
know that, but that was not necessary for the purposes of achieving the object that was in front of them.
Correct. I mean, it may be that they, if they had that information in front of them, nonetheless decided that it was worth the cost to make a statement as a moral imperative, nonetheless. But surely it cannot be said that without considering what that means, simply people saying, what are the financial implications? In other words, we think there may be financial implications, that's good enough. That surely cannot be
But
correct.
that argument can only work in a vacuum. Because on these facts, that very information was disclosed the following month. That very information was disclosed in March the following year. The actual rands and cents were disclosed.
The decision, but we're talking about the decision at the time the decision was taken.
Yes, but even that decision.
Let's just go back. Sorry to interrupt. Speaker number 1 and 8 they were adamant about the implications.
Sorry, my
680. Go to 680. 680 to 681. They were adamant about the implications. They wanted to know the implications. Although they never asked what the financial implications were. Nobody mentioned what the financial or asked. None of them. Don't we stand to lose anything financially if we do this? Then the Speaker 1 speaks about the values. If we go to 681, then a speaker says decisions have consequences, Chair. Then somebody says, Speaker 1 says, but that is a different consideration. Now, if we come to...
And then just at 682, my lord.
Yeah, if you come to, if you come to valuation, if you come to what rationality review is about, thinking for myself, it seems that if I read here correctly, maybe I'm wrong from my understanding of reading this, there was a concern about financial considerations.
Precisely.
There. It was there, and the chair also mentioned, the chair mentions, and Speaker number 8 wanted to know that. He didn't ask, but look, what about this? Although the other people knew about that there might be financial considerations. There was really, in my view, reading this record for myself, a concern about the financial considerations. They knew about the 2019 report. I know. some people were aware about it. You can see what somebody says here. He says the following says, now the financial considerations is a different consideration. Now, if we go back to the values of constitutional imperatives, I always think about if you abolish the death penalty and let murderers go because of the right to life and the right to dignity. We would rather let the murderer go, not be, let's not hang him, but he's got the right to life because we place a great score on that as a country. So if you look at the totality of the values we're talking about, the values of UCT, the values of our country, and the chairman says things here. He says that is a and somebody says that is a different consideration.
In fact, someone else, my lord.
The financial consideration here is a total different consideration. We're not concerned about, in other words, I'm not going to say it's an irrelevant consideration. We're not concerned about that. If you look at the whole debate here, the debate was what was happening in Gaza. And the point then is here, what he says here, 681. That is a different consideration. Because if that is a consideration, then you know it could also be regarded as quite a sad day that we are held to sort of hostage or to ransom because you know we are going to lose money.
Precisely. And
that was a consideration, a weighty consideration at that stage. Because that was a big issue in Senate. I remember a few years ago, and in fact, you were asked to make those records available. I don't know who these people are because we're talking about Speaker 1, 2, and 3, whoever. About what we potentially could lose if we adopt certain resolutions that are perceived to be anti-Israel. In other words, that was the financial considerations of adopting these resolutions were debated there. What it precisely would be and whether there's an impending withdrawal of the funding of the was not made known. But those that were present there had to have an inkling that financial considerations would play a part. And here we come with the weighing up. And this is where one comes to the rationality decision of what do you weigh up here? Are we going to, and this has been debated. Speaker number 8 wanted to know that. Okay, it wasn't answered, but then at one stage, this speaker number 1, I don't know if he was the vice chair, and then also the chair also spoke about that. So in no way they may have, and it may be so, and it is true, it is correct that the withdrawal of the Donald Gordon Foundation, the Dell Foundation, that was imminent. It was not mentioned, and they should have mentioned it. But financial considerations were. And some of the speakers said that is a different consideration. We are concerned with other considerations, something else.
They won't be beyond, my lord. You see, if you go to page 682, which is where I thought your lordship was going, Speaker 11. So Speaker 11 says, if you look from line 10, he says, but I sincerely feel that if we are talking about the criminal war crimes, and we know at that point on the answering affidavit that Netanyahu had been indicted by the ICC for war crimes. The starvation of people in Gaza and the West Bank, the murder of children, the destruction of education, the destruction of generations of Palestinians. And if we do not speak out about that, what are the implications of not speaking out and taking a firm or a bold stand? And then look at what he says next. I think the implications of not speaking out are greater than the implications of not getting more funding. He made a choice.
And of decision is made on those facts.
Well, Mr. Katobi, if you go a bit further, however, on page 693, you'll see speaker 11 says something further about that. Same speaker on page 693, the one that you've just referred to that says it is important that we stand on the right side of history, wasn't necessarily clear, because if you look at page 693, from about line 20 onwards, the speaker raises again. He says, for the past 3-4 years, we have heard about implications. It's usually got to do with funding. The bottom of the page. So when we reject a huge amount of money because someone supports the bombardment of Gaza, then I say, yay. But here comes the point. But let me know specifically what the implications are for the university, because it is quite dense at the moment and opaque. One cannot see through what these implications are. So you can build consensus with the two positions based on the one in relation to what is being said. We know the figures regarding loss of life. So they're asking that same speaker, notwithstanding what was said earlier about taking a moral position, is saying, please, what are the figures? What practically in real terms are we looking at? Did anybody give those figures? No, nobody gave any figures, despite knowing that it's going to be at least 200 million plus a couple of other 100 million. It's a large sum of money. Not one of those 5 members that were present at Exco came forward and said, these are the figures, this is the amount of money, and then say, now you take a decision whether you want to take a moral position, notwithstanding this cost. Then, as was debated earlier with Mr. Fagan, Mr. Fagan says, yes, then there would be no cause for complaint, because then the council had properly had all the information before it, was properly disclosed. If it then took the same resolution, nobody can say there was non-disclosure, there was a failure to have regard for rational consideration. But I, for one, am very troubled by what is going on here, because right through to the end, people are asking for information and none of it is forthcoming, specific information.
You should not be. Let me just finish what I was reading, because I was trying to finish my answer to Justice Henry here. So I'm going to answer this last point you've just made. But so on Speaker 11-682, so he says, I think the implications of not speaking out are greater than the implications of not getting more funding. It is about where we stand in history at this transition, where we have to speak up. I think it is absolutely important that we stand on the right side of history, and that by accepting this, the Senate proposal, and adopting the resolution as a university that is united against genocide and the kinds of war crimes that we have seen in Gaza and in the West Bank. And then look at how he concludes. I cannot say anymore. I do not even think it is a matter for debate anymore. The writing is on the wall. There is nothing left in Gaza, nothing left of Gaza. So he clearly made a choice. And to say, I think you should have given more weight to the rands and cents, is to ask a correctness question. This is no longer a rationality debate. It is the judges imposing their opinions on the UCT Council, which is simply not allowed in law.
What the relevant factors are and which have been omitted.
What they are not allowed to ask is what weight should have been given to a factor, which is what we are debating right now. But the question of financial consequences is fully debated, and the choice is made. We are going with moral imperatives. And he even says, this is no longer a matter for debate. There's nothing left of Gaza. It's clear that they made a choice that whatever the financial costs,
It's fully ventilated if it has not been disclosed the actual impact.
But the actual impact, that's what I'm saying. That actual impact is about weighing what weight should be given to the financial consequences. That is not required for a rationality inquiry. So that's what the case law shows. That's what I'm accepting your ladyship's proposition. But I'm saying it would have been a fine distinction to be made for a reasonableness inquiry. But it is not a factor here because this is a narrow rationality inquiry.
Would it not be so then that failure to consider relevant considerations, if we put it that way, can also constitute a serious breach of duty?
No, because it's just a ground of review under legality. It's not itself a breach of duty because the breach of duty, you need to identify the duty. But the failure is, this is a ground of review that we're debating. We're debating the contours of that ground of review. I'm saying there are two things that are excluded from that ground of review.
The code says you must act with a certain standard of diligence and care. That sets your legality standard for you in the code. It says your duty is to do the following: to act with skill and care for the university. There it is. That's a legality. That's a legality standard.
I must confess, I don't remember that the grounds of review say that you failed to comply with the code in relation to that issue. But I stand to be advised. But I think we have to be very strict on keeping the applicant to the pleaded case and not expanding the case of the applicant.
So your argument was there was rational debate
Precisely.
about the resolutions they made, although the loss of funding being in the minds of some of and people knowing about it was not disclosed. The question of loss of funding was a factor that was considered. So in the rationality test, that all has to be put into the into the equation, and then ask ourselves, notwithstanding that, or let's say they've argued this, they've debated this, they've asked the questions about the consequences, they've asked the questions about the funding, they've debated about that ultimately. At that stage, notwithstanding that, they came to that conclusion. And then you go to the second stage on the 15th of
On the 15th of March is probably the more expansive one, because at that point, the papers we are dealing with now had been drawn up and they were before the council, including, by the way, usefully, a report by the Vice-Chancellor, which expressly stated that there is a risk of further losses. And because why the Vice-Chancellor said that, the Vice-Chancellor was saying, I am asking you to rescind, because if you rescind, you're going to help me in my negotiations with the funders. That was before them. They took that into account. They said, this is a moral resolution. Nevertheless, they passed it again. So one must be very careful not to substitute one's own beliefs about what would have been a correct resolution. One must accept that the council is acting in pursuit of its own interpretation of the laws that govern it. We may not like it, but that's why the rationality review says, don't impose superior wisdom. Don't impose your own wisdom over the administrators. They've made the decision. They've taken into account what they should have. They've taken into account twice everything, and they've come to the same conclusion. And we may not like it. The fact of the matter is that it's a lawful resolution.
That as a court, we should not consider the relevant factors.
I agree with that. You have to know when it stops being a relevant factor into a weighing.
were these relevant factors?
It's clear that financial considerations were regarded as relevant and objectively speaking would be relevant. The question is the weight. The weight was up to the council to decide. There's a judgment that I need to cite, I think, because we're now debating this for the second time. And I keep saying the weight is for the council. It doesn't enter into rationality. But let me just take the court to the authorities that make that point explicitly clear.
Some factors may weigh more, may be more weighted than others.
Yes, it's paragraph 54 of our heads of argument. So, in fact, it's a citation of Lawrence Baxter. I think Mr. Butland would be very impressed that Baxter is still around. So if you go to it's paragraph 54, it's a case of Clarison's CC. And so it's 2 paragraphs down where it says, it has always been the law and we see no reason to think that Paja has altered the position that the weight or lack of it to be attached to the various considerations that go to making up a decision is that of the decision maker. Then they cite Baxter. As it was stated by Baxter, the court will merely require the decision maker to take the relevant considerations into account. It will not prescribe the weight that must be accorded to each consideration, for to do so would constitute a usurpation of the decision maker's discretion. The law remains, as we see it, that when a functionary is entrusted with a discretion, the weight to be attached to a particular factor or how far that particular factor affects the eventual determination of the issue is a matter for the functionary to decide. And as he acts in good faith, a court of law cannot interfere. My lady, I say it's 1544. Yes, I know the debate can consume one, but the time has arrived. I don't know what you want me to do.
And we may pause the proceedings. But I also want to suggest something. Is it possible for us to start at 9:30 perhaps so that we can cover that?
I will probably be going on for another hour and then I'll finish. Tomorrow, yes.
9:30 then tomorrow.
Yes, please.
Correct.
Well done.